All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near. Give attention. You shall be heard. God save these United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Florida Bar versus Michael Christopher Grieco, case number 20-1118, and Justice Coriel is recused. Whenever you're ready.
May it please the court, Mark Mason on behalf of the Florida Bar. Next to me is my paralegal, Melissa Howland. Before I begin, I'd like to just note as a preliminary matter that there is an order sealing records in this case that was entered on January 31st. So for purposes of today's hearing, given the public
Counsel,
nature.
Could you speak up a little bit?
Sure. I think I'm not close enough to the microphone. For purposes of today's hearing, I'm not going to reference the witness affidavits in the criminal case, since that was the basis for the sealing of the records. This is Mr. Grieco's second disciplinary case since becoming a member of the bar in 2000. His first disciplinary case, the conduct involved in that one was that he misled police investigators into falsely believing that his inquiry into the case was related to his role as an assistant state attorney. It wasn't. He was contacting them because his friend was a suspect in that investigation. He received information that otherwise wouldn't have been shared with him, and he later told the investigators that he didn't think they had probable cause for arrest. For that, he received a public reprimand in 2008. We're here again because we're dealing with similar misconduct involving misleading others. In two instances, one was receipt of an illegal campaign donation. He received it from a Mr. Rodriguez, but the money actually came from another individual, a Norwegian citizen named Mr. Hagland. Okay? He received this money knowingly. That was the criminal charge. That was the criminal information that he pled no contest to, that he received it knowingly and willingly. He later returned that money, and according to Mr. Rodriguez in his testimony before the Miami-Dade Commission on Ethics, he was told at that time, if anyone asks, tell them that it was your money. The referee found all the findings of fact that the bar wanted them to find, made all the findings of guilt that we sought, which was 3 findings of guilt for the 2 instances of misconduct, both related to the campaign donation, but also to the misleading statements in the press. Specifically, the money that was deposited, along with about $200,000 of other money that was raised, was deposited into a political committee's account, People for Better Leaders. Now, on paper, there was no connection between People for Better Leaders and Mr. Grieco. But in actual fact, he had everything to do with it. That was the finding by the referee. He fundraised all of the money, save for a single $250 donation. He did all the paperwork to set up the organization. He did all the compliance paperwork going forward. So this notion, which has been re-raised in the briefs, that, well, he didn't own and control this committee, it's really a fiction based upon his use of 2 straw men who served as officers of that committee, but really performed no meaningful work for it at all. That was all done by Mr. Grieco.
Let me ask you this. The second violation to 4-8.4C, the misrepresentation to the Miami Herald, would it have been any different had he made that representation, say, in speaking in a political type of setting where he is speaking to a group of people? If he had made misrepresentations in that type of setting, would it have been the same violation?
It could have been the same violation. And I say that because the rules we charged him under, all 3 of them, are not related to the practice of law specifically. They can be violated by conduct outside the practice of law.
That's what I'm thinking. So what the bar is suggesting here is that people who run for public office, if they happen to be lawyers, they can't make any misleading statements anywhere.
Correct. This court has stated a lawyer is a lawyer is a lawyer. That's a direct quote. I didn't make that one up. A lawyer never takes off his lawyer hat was another one.
So it could have been a statement at somebody's house fundraising function or any place.
Professional life, I believe, is how the standards phrase it, how the rule phrases it. And what we're talking about here, I want to be very clear, it's not political rhetoric to say, I have no involvement in this political committee. That's not political rhetoric. It's just a false statement of fact. It's not true.
Are you concerned at all by the fact that the evidence of the false statement is a blog that's picked up by the Miami Herald versus words that are actually coming out of somebody's mouth? I mean, that would be breaking new ground, you would agree, in our case law, right?
If this was based solely on a blog article, I'd fully agree. But the blog article is just how this began. There was an anonymous email that this blogger reported on that said there was an allegation linking him to the committee. Then there were the 3 Miami Herald articles that kind of drum up and turn into this much bigger issue. But this notion that, you know, all we have is a blog article, all we have are newspaper articles, it's not true. We have the context because Mr. Grieco has testified about the context several times. And so his testimony is constantly, I was asked every which way about my involvement, and I always said I didn't own or control it. And that was a precisely true statement.
So isn't the issue, when you say that a lawyer can't ever make a misleading statement in public, that's not really the issue here. It's the cumulative context, and I think what the referee was emphasizing was that the veracity of the allegations was proven through the bar investigation of the trial. It's not merely a lawyer saying something misleading in public, right?
Right, and it was done with the specific motive of trying to obtain a higher office, specifically mayor office. And
Was that finding made?
that was the
Finding as to motive? I thought there was no findings as to motive.
What the referee said was that he was trying to avoid a political scandal in the report. That was what the finding was made. And the context of that I'm providing, because it was testified to, was that he was currently in a campaign to be mayor, and he dropped out of the campaign shortly after.
Do you think that the statements alone, or that what appears to be a misleading statement proven only through a blog article would be insufficient for somebody to lose their license for a year?
If this was just a blog article, we didn't have the blogger testify as to the context of the statement, no, that wouldn't be sufficient for a year.
Okay, so the additional context has to be here.
Correct.
For your argument.
Yes, and there is additional context, because I want to be clear, this wasn't just the bar put in evidence, the newspaper articles. We had transcript of a 3-day Miami-Dade Commission on Ethics hearing where there was substantial testimony about the context for these statements. And what the context was that 2 reporters from the Miami Herald came to his office and they asked him every which way, and he categorically denied any involvement. So this was a misrepresentation by omission given his in-depth involvement with that political committee.
Do you think, given the fact that the prior disciplinary history and the charge having to do with the criminal issue, that to justify the 1-year sanction that you're asking for, do we even need to consider the other stuff?
When you say other stuff,
The media issue, the misleading statements.
I think it's only relevant in the context of this court treats cumulative misconduct harsher than it would treat isolated instances. And so, yes, we already have cumulative misconduct just with regards to the public reprimand and then the subsequent illegal campaign donation that resulted in the first-degree misdemeanor charge. That alone is cumulative conduct, but I think it is important to add in the additional context of he didn't just make this mistake, this accounting error, it seems like it's trying to be categorized in the brief, and that was it. he was trying to raise money secretly through this political committee, avoid any kind of involvement on paper, and I think all of that needs to be considered collectively in determining the appropriate sanction.
What about misleading statements in the course of the bar proceedings?
Right.
Would you elaborate on that?
Sure.
Because that's part of the picture, too.
This is part of the picture, and I was going to get to that. Thank you. So first off, when he sent a letter to the bar, or I should say Mr. Cuny sent a letter on his behalf, the representation made was that Mr. Grieco did not initially tell the reporters about his involvement in this political committee because he was the lawyer for the committee, and he was not authorized to do so under attorney-client privilege. That was the original basis. Problem with that position is that it wouldn't authorize him to make misrepresentations to those reporters. The testimony then shifted by the time of the bar trial, and suddenly he's categorically denying ever being the attorney for the political committee or the founders of that political committee, who were Brian George and Brian Abraham. He said he only did some clerical work and that was it. He was never a lawyer. So he changed his statement then. And then I noted in his answer brief, he's changed it again. Now he's saying, well, I wasn't initially the lawyer for the political committee, but then I became the lawyer later on when the press started asking questions. That is a statement made without citation to anything in the record supporting it. It contradicts the letter he sent to the bar when he said he was charged as the attorney with organizing it from the outset. And the referee found that he offered two diametrically opposed statements. You couldn't reconcile them, which apparently the answer brief is trying to do by saying he wasn't originally, then he was. And the ref found that his specific motive in doing this was just change his story however it suited him best, whatever suited him in the moment. So he used the attorney-client privilege initially, but then his defense shifted to, well, it's not related to the practice of law, therefore I shouldn't be disciplined as harshly. But to do that, he needs to say, well, I was never the lawyer. So that adds in to this pattern of misconduct here. And that alone, I think, is a basis to say that a 90-day non-rehabilitative suspension isn't enough, because clearly this is just a pattern of dishonest conduct that began with the 2008 public reprimand, but it's continued into this appeal, very frankly. And in my brief, I've cited to a few cases that also didn't involve the practice of law, but still resulted in significant penalties for the lawyer. Kinsella.
Well, he brought his status as a lawyer into the case when he argued that he was not forthcoming because he was a lawyer.
Mm-hmm. Right. And it's this kind of notion that, you know, we're going to treat it as though he's a lawyer and then he can do this, but then in the same breath, in his brief, he's constantly saying, well, I'm a politician. I need to engage in the rough and tumble world of politics, his words, without constraints that would apply if I was a lawyer in a courtroom. This is just reflecting a very troublesome view that, very frankly, justifies a significant rehabilitative suspension
I mean,
period.
there's different obligations, obviously, that apply when you're engaged in political rhetoric and when you're engaged in a courtroom. But isn't your point, though, it's not political rhetoric in a vacuum. It's the full context of misleading during the bar investigation and the veracity of the allegations being demonstrated through the investigation.
Correct. I'm looking at this from a very global view, so I'm not trying to view it in terms of only the statements to the press, only the illegal campaign donation, or only his prior public reprimand for similar misconduct. I'm looking at this fully when I say that a significant suspension period is warranted. And I say that because this court has, in recent years, trended towards harsher sanctions for attorney misconduct. This court has suspended lawyers for multiple years for misconduct that was unrelated to the practice of law. There was the Kinsella case that I cited, which involved a young lawyer with significant mitigation. She stole from a Kohl's store $760 on 3 separate occasions that added up to $760.
But I'm sorry, just to be clear though,
Yes.
I mean, your position is that it's not about political rhetoric at all, right?
Correct.
We're talking about statements of fact.
We're talking about statements.
And you're saying that through this proceeding that we've had, that it was proven by clear and convincing evidence that these were untrue statements of fact that were intentionally misleading.
Correct.
So it has nothing to do with political rhetoric.
No, I'm not treating what he said as political rhetoric at all, because it's just a false statement of fact to deny involvement with this political committee. And the reason I cited Kinsella in my brief and argued it so heavily is because it didn't involve the practice law. It was just the theft, and it was a 3-year suspension, despite significant mitigation. Now, we're not seeking as harsh a sanction here. We're seeking a 1 year, and that's mainly reflective of the fact that the criminal offense is different. But it still warrants a significant suspension period. So with that in mind, I would ask that you suspend for 1 year.
Thank you.
Good morning. May it please the court. Ben Cuny. I represent Michael Grieco, who at the time of these proceedings was a representative in the Florida House of Representatives. He's now retired, did not run for re-election. This case is about political rhetoric. No matter the bar's position, the proof at the trial proceedings was truncated, was based on an exploration of testimony that should not be admissible, was not subject to any reasonable confrontation, and essentially resulted in Miami Herald newspaper articles and a blog posting.
I'm sorry to interrupt you.
Yes, sir.
I mean, we have the criminal issue, right?
Yes,
so
sir.
how can you say that the whole thing is about political rhetoric?
The briefs have pointed out, and the state, the Florida Bar has agreed, there are 2 parts to this case. I can address the criminal case first, which raises the issue of the fact of application directly to this court of the sealing statute and what is necessary to prove the bar's proof of an adjudication of guilt. And the bar did this on a sealed record, a record that had no certified copies of anything, and for which Representative Grieco was allowed to say under law, I have not been convicted of any crime. And that statutory language is quite clear, offering no availability for use of a sealed proceeding in bar disciplinary matters. The statute even going so far as to say there is an exception when it comes to bar matters, but that deals with bar application. The legislature has made clear that this is not usable. The bar attempted to prove by clear and convincing evidence, which it did not, that there was in fact a commission of a crime of dishonesty. And we've heard the bar take the position that this is a crime of dishonesty when it is not. The political contribution violation charged, and all we know is what the charge was. No proof by the bar of what the underlying facts were, no exploration of whether there was a colloquy to the court, all of which was sealed, and the bar takes the position that of course we know that a political contribution violation is a crime of dishonesty, when in fact the statute makes no such authorization, and the same conduct is ordinarily established administratively.
But the crime here is knowingly receiving a contribution that is given in the name of someone other than the real contributor. Isn't that correct?
That is the statute, 106.087.
That's what was at issue here, right?
On the criminal case, yes.
Well, I don't understand how doesn't involve dishonesty.
It has never been construed to be a statute requiring dishonesty. All it requires...
It's an intent to deceive, to report a contribution in the name of someone who didn't give it is, by its very nature, an act that intends to deceive.
And Your
And
Honor,
I'm puzzled by the argument that you're making.
Your Honor, it may very well be that proof could establish that offense being done with an intent to deceive, but the crime itself and the only
But it's
issue.
inherent. Why am I missing something and not understanding that it's inherent in the crime? To the extent that it is done intentionally, it involves an intent to deceive.
Your Honor, that
I understand, but it seems like you're making this highly formalistic argument that just detached from the reality of the underlying offense.
But it is not formalistic, Your Honor, in the connection with political contributions, mistakes, inadvertence, knowing something is not intentionally doing something with the knowledge that it is wrong. And that statute has never been construed by the Florida Elections Commission or the courts to imply or infer a violation of honesty, deceit. It just has not. And it may very well be, Your Honor, that circumstances, if proven, could show that somebody acted with that intent. But there was no such proof offered by the bar in this case, and there was no such proof in the criminal case because the criminal case did not resolve itself with a fact-finding basis. And since the bar charged Mr. Grieco with that violation under a bar rule that requires proof that it reflects adversely on his honesty, trustworthiness as a lawyer, this political aspect of his life, which was formative and very positive, was maintained independently of his work as a lawyer. None of the publicity that comes to the second part that I will get to in a moment, Chief Justice, dealt with the allegation that he is holding himself out as a lawyer, misleading the public. This was all in the political context. The political contribution, which could have been an administrative law violation, but instead it was charged for whatever reason as a criminal misdemeanor, the resolution of a case that led to a sealing and expunction, the bar having no adequate proof of the conviction, and having no basis under the statute to utilize the conviction.
Am I wrong in understanding that Mr. Grieco sent a letter to the bar telling them about it?
Your Honor, his counsel, myself, sent the letter under the requirement of the Florida bar advising of a disposition. It's not evidentiary. It wasn't proven as evidentiary.
It's an admission.
And the bar attempted.
Why is it an admission? I just see this argument as detached from reality. If I go to the bar and say, look, I've pleaded guilty to this and I've got a disposition in this for this crime, and then you want to come later and say, well, you can't use that against me, even though I told you that happened, I don't understand that.
So, Your Honor, there are two aspects to the trial.
I mean, this is a matter of candor here.
I don't believe that candor applies when there is a statute that says, as a matter of law, Mr. Grieco is allowed to say that he has not been charged or convicted of criminal conduct. That's what the legislature has determined.
Can I
Yes,
ask
Your
you
Honor?
a question about the proceedings and what he testified to under oath? According to the referee found specifically, he, quote, made misrepresentations in these proceedings under oath regarding his involvement with the PAC as its lawyer. And the referee also found that it was clear that your client's, quote, narrative and testimony regarding his involvement with the PAC changed depending on the audience to whom it was presented and the goal he wanted the statements to accomplish. The bar has argued that they're taking a global view. They're looking not only at the criminal offense. They're looking at the prior reprimand. They're looking at the statements that were false that he made to the Miami Herald. And they're also looking at these statements that he made during the proceedings that shifted over time and that the referee found were misrepresenting. Why isn't that sufficient to give the bar what it's asking for, which is a suspension for a year? Particularly because, the bar has pointed out that we have given a 3-year suspension in an analogous case where this attorney went to Kohl's and she stole the 3 times and, it added up to $750. Why should we not grant the bar the relief that they're requesting based on these particular findings and based on a holistic view of this entire case?
Justice Francis, the penalty under any circumstances of more than 90 days is too severe and not supported by abundant decisions, which we've briefed and the referee discussed. Let me break down your question, if I might, into 2 parts. First, we disagreed, and the brief makes clear that we disagreed with the referee's acceptance of the bar's position of this shifting narrative. And Mr. Grieco testified. He was cross-examined. His testimony was very direct on the first part, dealing with the statements, and he categorically denied. There was no impeachment whatsoever, no contradictory statements. Categorically denied owning or controlling political committees. Didn't talk about, said, I didn't answer questions about my association with it. His association was evident, but categorically denied. And the testimony at the bar hearing is that, as a matter of law, he's correct because of the nature of political committees, and as a matter of fact, he didn't control it. The political committee spent no money whatsoever. Second, Your Honor, Mr. Grieco made clear that when the alarm occurred and the Herald made this the blog and then the Herald made this the political rhetoric issue of the day, Mr. Grieco advised the 2 owners or controllers of the political committee, Brian George and Brian Abraham, to have legal counsel. And in that capacity, he provided advice to them. Prior to that time, and he never said anything to the contrary, prior to the time, he did not act as a lawyer in setting up the committee. In fact, the testimony is, I believe, from J.C. Planas and Mark Herron, undisputed, political committees are set up without legal advice whatsoever. That's a political activity. And third, with regard to the judge's determination of this global episode of an intent to mislead the public, this is exactly the slippery slope the bar got into with regard to attempting to hold Mr. Grieco in his political capacity responsible for giving factually true information to the public, to the Miami Herald. Nobody even understands there was no proof as to what the public thought of this. And having an obligation in a court, and they've cited a couple court cases where a lawyer has an obligation to a judge or to the opposing counsel to fill in the blanks. There is no such fill in the blanks requirement for political rhetoric, and yes, it is political rhetoric in this case. So we believe that even if the court is apprised that the fact of a criminal conviction is sufficient, we do not believe there is any clear and convincing evidence to support the fact of making misleading statements to the press. Putting up a newspaper article and asking Mr. Grieco to explain it, and he does, without contradiction, is not proof that a lawyer has misled the public in a capacity that would affect his trustworthiness as a lawyer. On the misdemeanor matter, if the court finds that that is sufficient, and we've raised significant reasons why there was no sufficient proof, this would warrant at most a 90-day suspension.
So now, why did you say there wasn't sufficient proof of the misdemeanor again?
Your Honor, three reasons. One, there was no certified copy of conviction, which is the nature of proving the case. And remember, the Florida bar only operated on the presumption rule, the rule that says an adjudication of guilt is conclusive proof. They did not establish an adjudication of guilt as that proof is required under any circumstance.
But again, I go back to what I said earlier. You admitted it. If it's admitted, it's admitted.
Yes, sir. That was done through a lawyer's letter. There was no testimony connecting the lawyer's letter to an admission by Mr. Grieco.
I don't understand why that's not sufficient.
There was no connection to it at the bar hearing. But secondly, Your Honor, the fact that there is even if the court finds that's sufficient, it still doesn't step over the line of establishing that offense affects Mr. Grieco's trustworthiness and honesty in connection with the practice of law. This was I hate to say a separate matter because we want to encourage lawyers to be involved in the political process, but this was all in the political milieu, not having any even slight oversight
Can I
with
just
the
ask you
bar.
a quick question?
Yes, sir.
Was this plea a no contest plea?
The evidence reflects that it was a no contest plea.
So,
And that was, excuse me,
back
Justice,
on
that was through a lawyer letter.
back from my criminal law days, no contest, when one enters a no contendere plea or no contest plea, basically you're saying, I'm not pleading guilty, I'm not pleading innocent, I'm just not challenging the facts.
Yes,
So
Justice.
how does that consider an admission?
The bar rule on the conclusiveness deals with the adjudication. So if an adjudication is established, how it got to an adjudication doesn't matter. Here, there was no adjudication, but a withhold of adjudication is considered in the bar rule.
Assuming for a second that the court is going to rely on the letter sent to the bar by the attorney. The letter sent to the bar by the attorney says that Mr. Greco pleaded no contest.
Correct.
So it would be the admission. Whether it's an admission or not, that would be the factor. You see what I'm saying?
Yes, Justice, and that's the problem we have here is the bar, I'm not going to say could have done it, but due process would have required, even in a bar proceeding.
But
Yes,
the
yes, sir.
rule specifically says that determination of guilt under the bar rule includes those cases in which the trial court in the criminal proceeding enters an order withholding adjudication of the respondent's guilt of the offense charged. Okay, so the withhold doesn't make a difference. In those cases in which the convicted lawyer has entered a plea of guilty to criminal charges, those cases in which the convicted lawyer has entered a no contest plea to criminal charges.
Correct.
So the fact that it's a no contest plea doesn't take it out of being a determination of guilt under the express terms of the rule, correct?
That's correct, Justice Kennedy. The issue becomes, in a bar proceeding where Mr. Greco's license is at issue, and we understand the importance of this, can the bar short-circuit the ordinary requisites of proof by not using a certified copy of conviction, which would conclusively answer those issues, Your Honor? They don't have that. They don't have that. They have a lawyer letter that I understand the court would say that's an admission, but it's not proof of an adjudication or a criminal case resolution.
You can have 30 seconds to finish up.
For these reasons, we would ask the court to determine, one, that there is not clear and convincing evidence of the 3 bar violations and no implication on the practice of law with regard to the traits of honesty, integrity, trustworthiness. But if this court determines that there is a founded basis for a bar violation, the referee's determination of 90 days is the most that would be appropriate. We think, as the brief reflects, this is the case for an admonishment. The prior conduct in 2004, 2008, when Mr. Greco was a 4-year lawyer, has been sufficiently distanced by a lifetime of good work serving the public and the profession. Thank you, Your Honors.
Thank you very much.
I obviously won't touch on every point. I did want to note one thing. I've heard now that Mr. Grieco didn't originally serve as lawyer for the People for Better Leaders, but then he later gave legal advice to the two officers when he told them to go ahead and wind it up. It wasn't worth it. This was his testimony at the hearing. I just want to read it. Were you ever retained by People for Better Leaders as a lawyer? And his answer was no, not by the committee nor by any of its officers. He wasn't the lawyer. That didn't become a new issue until it was raised in the answer brief, and now it's been re-raised today. It's not true. With regards to the letter from Mr. Cuney, where he specifically said, he said he pled no contest. That's sufficient evidence. The bar has lax evidentiary standards. It's meant to reflect the fact that we're dealing with lawyers. We want to know what happened, not get hung up on technicalities. We have an admission from Mr. Cuney, who was Mr. Grieco's lawyer.
Counsel, does
Yes.
it concern you at all that the bar requires a letter to be sent, and then that can be used as an admission against them under your evidentiary standard to prove it?
No, Your Honor, and I say that because the rule doesn't just require a letter. Technically, it also requires him to send over the actual court record, which wasn't done. We didn't get that, but we did have the underlying letter, so honestly, I don't think there was any indication at the outset that this was ever going to be an issue, because we were sitting on the admission the entire time. So would it have been nice to have the court record? Yes, it would have been nice if Mr. Grieco and Mr. Cuney had turned that over when they sent the letter, but it didn't happen, and we relied upon what we had, which was sufficient by itself to establish the violations charged. Now, as far as the case law goes and the notion that this is at most a 90-day suspension, I would just ask you to turn to page 65 of the answer brief, where they start citing to 11 different cases that they say supports that. All those 11 cases, the punishment was either 90 days to 3 years, nothing lower than 90 days. So when you're considering the pattern of dishonest conduct here, I'd ask that you consider going a lot higher than 90 days and more closer to the 1 year sought by the bar. Thank you.
Thank you very much. The court's going to take a 2-minute break, and we'll be right back.
All rise. Florida Supreme Court is back in session. Please be seated.
May it please the court. My name
Hold on a second.
Thank you, Judge.
We'll now take up Ivy Chase Apartments versus Ivy Chase Apartment Property, case number 221627, and Justice Sasso is recused. Go ahead.
Thank you, Your Honor. May it please the court, Chief Justice. My name is Jonathan Hayes, here on behalf of the petitioners, Mrs. Gail Curtis and Ivy Chase Apartments Limited. I'd like to reserve 5 minutes of my time for rebuttal. Your Honors, to the extent...
Could you speak up, please?
Certainly, Your Honor. Is that better? Thank you. To the extent the opinion on review permits yet another trial in this matter on damages, it presents 3 distinct legal issues. The first is when a plaintiff at trial fails to prove their case, under what circumstances are they entitled to a new trial? What are the limits on appellate discretion in this regard?
If you stipulate to an element of a plaintiff's cause of action, haven't you essentially absolved the plaintiff of its burden on that particular issue?
In that hypothetical...
Well, I don't know how hypothetical it is. Does your client contest default?
Your Honor, the client has not contested default in this matter.
So there's no dispute here that there is an amount due, right?
The dispute is as to what amount due and to whom.
And in the second proceeding, the creditor in this case adopted the lower amount that you said was due and assumed that that was the amount in controversy, which sounds to me a lot like conceding the point and assuming your client is right on it. What am I missing? How is that not, first of all, the fact that it was passed upon in the first appeal strikes me as makes it sort of res judicata. And second, it doesn't seem to me to be within the scope of the remand order at all. It doesn't sound like if there were additional proceedings consistent with the DCA's opinion in this case that there would be a retrial on default. What am I missing?
And, Your Honor, I think the primary issue is the failure to demonstrate the damages. So there's a couple of questions.
There's no failure to demonstrate the damages if you concede it.
And, Your Honor, at no point have we conceded. The documents that were presented in defense after the close of the plaintiff's case, after the motion to dismiss was wrongfully denied, as the Second District Court of Appeal found below, we introduced some documents years old to demonstrate at a certain stage that this was the level of damages that was asserted when there were still lenders in the case, when there were still loan servicers in the case. This is the amount of principal that they asserted. There has never been any documentation to demonstrate what the effect of the years of rent payments going into the receiver has been on that principal amount.
You're talking about interest now, right?
Either interest or principal.
Well, I think that's a significant difference because as I understand this note, which takes out the original 1994 note, the 2010 note is essentially a one-year note, right?
Yes, Your Honor.
And it seems to me like we know as of, December of 2011 that note is in default, right? Again, you don't dispute that. So if there's a dispute, it's not about the principal amount. It's about interest and about your usury argument, right?
It is certainly about the principal amount has certainly been affected or should have been affected over the years of payments that have been made into by the renters in this case.
I guess what I can't get my head around in the end here is I don't understand how a remand could be consistent with the proceedings before the court below if it was a remand for an involuntary dismissal where the proceedings before clearly established the existence of a default and an amount due and owing. How could that? There's no way that a remand could be consistent with those findings if it discharged you of your debt.
Your Honor, I think that there is a significant misconstruction of the record that is reflected in the Second District Court's opinion. This case is a little bit procedurally complex, and of course, as Your Honor has referenced, this was the second time that this case was before the Second District Court of Appeal. Reflected on page 16 of the order on review, there is a statement that is simply incorrect as a matter of fact. That is that the initial motion for summary judgment, the initial motion for summary judgment was denied outright in 2017. In 2018, there was a second motion for summary judgment that was granted in full, and it issued a final order. The Second District Court of Appeal miscites that
stating that there was some reservation as to the damages amount. There is no distinction in this case between someone who showed up and proved at certain elements of liability, but failed to prove other elements, in this case, damages. The remand the first time remanded for multiple purposes. One, it remanded in order to establish the damages amount, to establish the attorney's fees amount, and anything else that hadn't been previously determined by the court. To the extent the court determined anything previously, that order was vacated. I would direct the court to page 2177 of the record below. The final order, granting final summary judgment, was set aside. There was no successive motion for summary judgment. There was no successive order, or there was no successive order granting partial summary judgment. The order was simply set aside. There is.
I'm sorry to interrupt you. Could we take a step back?
Certainly, Your Honor.
I have tried in vain to find the conflict that we're supposed to be resolving here. So, just so that we're starting from a shared sort of common assumption, I mean, no one says that there's a categorical rule that applies across all cases as far as what the appellate court is supposed to do, right? There's always, it's sort of, everybody agrees that there's some kind of exceptional circumstances carve out or judicial error, you know, in Emis's opinion in the third DCA. And here, of course, we have no analysis that goes to what this particular court in the disciplinary review was thinking as far as why they chose to remand for further proceedings, right?
I agree that there are no.
So tell me what is the rule of law that this case stands for, and what is the case that rule of law conflicts with?
I think there are two material conflicts. The first is that to the extent this case is remanding by readopting the some evidence, no evidence chain of cases as evidenced in Wolkoff and in Sass, then I think that this conflicts with the rest of the district courts of appeal that find that there must be some exceptional circumstances. And in Tracy, the second district court of opinion stated what those exceptional circumstances were. Those exceptional circumstances are when the court errs, and by erring, it keeps the plaintiff from making its case.
But counsel, let me, there's no reasoning about this.
Agreed.
In the opinion. I mean, all we know about, but even beyond that, counsel, isn't it your position that you have articulated consistently that you don't really think that that understood properly, that the district court's opinion actually gives them a second bite at the apple, as you call it? Okay, so you're saying that at best what the district court said is ambiguous.
Agreed.
I am struggling, as the chief has struggled, to understand how there can be express and direct conflict based on ambiguity. I mean, that just does not make sense to me. If we have express and direct conflict when we have dueling propositions that are clear, that are express and are in collision and cannot be reconciled. And you're saying, well, maybe this gives them a second bite of the apple, and to the extent that it does, we think that's wrong. But that just doesn't fit the framework, at least the way I understand it, of express and direct conflict. What am I missing about that?
Your Honor, I believe that the Second District Court of Appeal absolutely could have created more clarity, which is why a motion for clarification was filed below. To the extent the court finds that this order is not unambiguous and the order is requiring dismissal below, because the
we
court,
don't have jurisdiction.
and I think the court could certainly opine that in any order finding that the jurisdiction was not in this case. That is, to the extent the court determines that there is not jurisdiction in this case, it could certainly opine that the reason it lacks jurisdiction is because this case is to be dismissed below,
Counsel,
and thus there's no conflict.
It was you who brought up this conflict.
Yes, Your Honor.
That you then decided was ambiguous in your merit briefing.
Yes, Your Honor.
So is the argument you made in your jurisdictional briefing the one you want to make today? Or are you going to go with it was ambiguous and we don't have jurisdiction? Because they're two very different arguments.
Your Honor, I think the ambiguity stems from the fact that there are multiple remand instructions in this case. The first set of remand instructions, and I do believe that in the jurisdictional briefing we did raise the issue that it's not entirely clear what the intent of this order was. The first remand instructions say we remand in order for further proceedings consistent with this opinion. That is immediately after the Second District Court of Opinion opined that the motion to dismiss was improvidently denied, that it was required to have been granted. It was an error to deny that. And so that would certainly indicate that the requirement here is dismissal below. The remand instructions at the end of the opinion themselves cite to two different cases. One case is the Tracy case, which certified essentially the first legal question to this court, that is, what are the circumstances that permit remand for a new trial? And that case remanded for dismissal in Tracy. The second case returned to an older set of case law, that is the some evidence, no evidence standard, in the Sass versus that mortgage case. And there's a parenthetical, and it's not clear if the parenthetical is to be entirely directive. To the extent this court finds that it is, that the point is that this opinion orders the trial court to rehear the damages hearing, then certainly there is a conflict.
But it sounds like we would have to sort of impute. We'd have to go through a lot of work just to come up with this supposed rule of law that this stands for before we can even decide whether that conflicts with something else and then how to resolve the conflict. I mean, that just doesn't seem like what we're here to do in a conflict case.
Your Honor, to the extent that the court finds that the crafting a rule of law as it relates to the scope of remand, I agree. It's complex. The state of the case law itself is somewhat ambiguous. However, what is not ambiguous is that if there is a new trial permitted, it is clearly excused, that is, this opinion has excused a successor in interest or purported successor in interest from having to prove their own standing in a foreclosure matter if a prior plaintiff has proved their own standing, which is absolutely counter to a number of cases, as we briefed in both.
That sounds like a very different conflict, though. I mean,
I agree.
We don't have before us whether ICAP stands in the shoes of Wells Fargo. That's not part of your briefing, right?
It was absolutely a part of both the jurisdictional briefing.
No. My question is, that's not before us today, right?
It is before Your Honor today, both in the initial brief and in the reply.
What case conflicts with the standing holding? And I mean,
yes, Your Honor.
Because that's a different alleged conflict than what we've been talking about. We've been talking about the alleged conflict about the remand instruction.
Correct, Your Honor.
So,
and the cases that we briefed were Kiefert versus Nation Star Mortgage LLC, Vieira versus PennyMac Corp., Koifman versus Pledger.
Your case comes out differently than all of those on standing.
Yes, Your Honor.
I'm sorry, I just don't see that in the papers. I don't see that as your argument before us today.
And Your Honor, my apologies. We certainly intended to brief and certainly believe that we were briefing the issue that the fact that the successor in interest or purported successor in interest is required to prove their standing. And we cited many, many cases that for the proposition that one, the trial court, the Second District Court of Appeal seems to have conflated the standards for proving standing in a foreclosure matter and filing a motion for substitution throughout.
But isn't that just that is a factual wrinkle. The problem with comparing these cases is that they are complex and there are factual differences that can lead to different treatment. And it just creates a real problem when you're trying to establish the conflict jurisdiction when you look at the facts and there's something different here that could lead to a different result. And so these cases just are not, as we said in law school, on all fours, okay? They're these distinctions. And it just seems like to me, because when I go through all the cases you cite, I'd say, well, yeah, I understand there's something here that he's talking about, but then there's this factual distinction. This is different. There's a factual distinction that could lead to a difference in treatment.
Your Honor, I would posit in response that the very case on which the Second District Court of Appeals relied, that was Island Roofing, it doesn't in any way support the concept that a successor plaintiff can step into the shoes of the standing of a predecessor who's established it in the absence of any demonstrable proof. We cited numerous cases. To the extent there's a factual distinction, I'm not aware of what they are. They haven't been briefed that they were material factual distinctions. I believe that this case is factually indistinct from the overwhelming majority of cases. It says that a foreclosure plaintiff has to prove that they have the original note, that they have the original assignment, that they have the original allonge, and it has to tender those in evidence. There are numerous cases that we briefed that find that a motion for substitution, one, is not the appropriate time to object. It is not the time at which a plaintiff has to prove that they have standing. And we're not aware of any other case that permits someone to just jump into the shoes without proving that they are the entity that is entitled to foreclose. I see that my time has expired. With that, we would request that the court remand with instructions for dismissal.
Thanks. And you have that time left as your rebuttal time.
Thank you, Your Honor.
May it please the court. My name is Alan Poppy. I'm with the law firm of Saul Ewing, and I represent the respondent. I'll refer to them as ICAP for short. I know the names are somewhat similar, so I'll refer to them as the respondent or ICAP. I would like to sort of shift gears in what I had planned to talk about and instead address some of the points that have been raised here, and I'll start with the Justice's point here, which goes to the statement of the case. There is no issue with regards to default in this case. Default has never been defended against. The defenses have always primarily been about standing. There was a finding in the final judgment that there's a breach of a loan documents and there's been a default. That's never been appealed. Okay, so there's no real dispute about default or about liability. The only issue that came up on remand before the court was the issue of damages. And just to clarify, I'll go to what the actual language was of the initial Second District's opinion. It said, the only two material issues that remain in dispute concern standing. This was the issues that were up on appeal. Our decision resolves the issue of standing in Elizon's favor, and the parties have not challenged any other rulings of the trial court in this appeal. However, Elizon acknowledges issues concerning damages and attorney's fees remain to be resolved. In light of the trial court's order and Elizon's acknowledgement, on remand, the trial court shall conduct such further proceedings as are necessary to resolve all remaining issues not previously determined, including damages or attorney's fees. So I notice that language that's a little bit broad there, but it's clear when the case came back down on remand, they already said the only issues were standing, we resolved these, we're just going to try to set the amount of damages. And in this case, it's important for the court to understand the promissory note here is about $1.2 million. It was for 1 year. When it matured, it was due. There were payments during that course of the year, monthly payments. They admitted to default. They admitted that they didn't make the last two payments. The math is pretty simple. 10 payments, subtract those payments.
Given the simplicity of the math, is petitioner right that you made a tactical decision? And if so, what was the tactical decision to rely only on Mr. Geigel's testimony and not just introduce into evidence the ledger that you received in response to that interrogatory? Why didn't you just move it in?
Right. Your Honor, I was not the trial court lawyer down below. And I'm not here to tell you that what the trial court lawyer did was correct. I'm not here to tell you that the court's ruling that the testimony of Mr. Geigel based on the business records, which were not submitted, was wrong. That was the correct ruling. The question is, what do we do on remand? I don't think there is a strategic or technical decision in the sense here that requires involuntary dismissal as opposed to a remand for further proceedings. And I'll answer your question. I may be a little verbose, but I'm going to answer your question. I'm not avoiding it. There's a couple reasons. First off, I think the conflict we're really talking about, the rub here, right, is do you get a second bite of the apple? And there are two competing interests at play. And this wasn't really talked about so much in the briefing, and so I think it's good here for oral argument. The competing interests are, obviously, we want finality, right? That's the interest that the petitioner is arguing for here. We want finality in our decisions. We don't want excessive litigation. We don't want you to come back and expend all these fees to go back and try this case again. The competing interest here is an interest of deciding the case on the merits, okay? And this is also in our jurisprudence, okay? It appears, and I'm not going to say we should accord the same sort of liberal standard, but we see it in our jurisprudence. We want to decide the case on the merits when we deal with amendment of pleadings. We talk about it in cases of vacating default judgments. So we have these two competing interests, all right? And the case law, and I think the way to talk to the Chief Justice's comment about these cases sort of being all over the place, and they are. They're very fact-specific. But I think there's a line in the cases that we can discern which separates when are we going to favor finality and when can we decide these cases on the merits. Because I think we want to decide cases on the merits, right? The scope of remand and what we do on remand, all the cases talk about we are guided by principles of equity and justice and fairness.
Those are very diffuse interests, though. You're not conceding, are you, that there is in fact a conflict for this court to resolve that gives us jurisdiction? I understand your position to be that you continue to believe we don't have jurisdiction.
I do not believe there is a conflict. To be a true conflict, there has to be sort of analogous facts, four squares, and different rulings. And I think in this case, and I'll try to divide this line here, the Second District correctly followed what its case precedent was, the Sass case, as opposed to the Walkoff case. That's the cases in the Second District, they always sort of are the diametric opposites. It correctly followed that case, which is on a certain set of facts. And that case doesn't conflict with other decisions from the 4th District and from the 5th District, which we also cited in our papers.
So, counsel, would it be your position that based on the very fact-specific nature of these types of cases, particularly mortgage foreclosure cases, that it would be virtually impossible for us to ever resolve this question because every case is going to have different facts? And so it should just essentially be the discretion of the district court in fashioning a remand instruction that might look very different one case to another because there would be no way to have uniformity. Is that?
Close, yes. I think the decisions are all very fact-specific. I argue against and caution against categorical bright-line rules here, okay, because I think the facts are very diffuse, they are very difficult, they are very complex. I think the trial courts, or excuse me, the appellate courts are accorded decision or accorded discretion, and they should exercise it on a fact-specific basis, and it's difficult to come down with a bright-line rule. I'll also add, which was not discussed too much in the briefing, but there is a statutory basis here, right? It's 5935, which accords the appellate court, says the appellate courts may, if the error is such, remand for further proceedings, right? So there's a statutory basis here. The legislature clearly grants the trial courts with some discretion, which again is diffuse. I understand that. How do we, and what do we do? And I think they are very fact-specific. I do think there is a line, and if you look at the cases that are in the briefing, there is a little bit of a rhyme or reason. I don't think it came out clear in the briefing. I'm going to try to discuss it here today. Let me be your guide. I'm trying to be presumptuous here, but let me be your guide. I think I can find a line here, okay? And as I said, I think we're balancing the desire for finality against the desire to decide cases on the merits. And the cases seem to come down on the side of, do we have an admissibility of evidence issue where the trial court makes an erroneous ruling, the appellate court corrects that ruling, and then leads to a sufficiency of evidence issue, versus what is more of a pure sufficiency of evidence rule. And I think what we try to do, and what I'm going to encourage this court to do if it wants to discern the cases and discern any rule here, is we like to get as close to a question of involuntary dismissal versus a question of, first, was there an evidentiary issue which leads to that sufficiency of evidence issue, because that again comes down on we're deciding the case on the merits as opposed to deciding on a technicality. And so let me explain the cases. In our brief, all the cases that we cite, this is the Saas case, which is what was cited in the Second District's opinion, the McMillan case, Webster case, Beauchamp, even the Heller case, which they cited in their brief, favors us, our side. These are cases from the Fourth and from the Fifth. These cases almost all uniformly involve a witness testifying. The witness doesn't have personal knowledge, but the witness testifies based on business records. They look at a payment history. They say, look, here's the records. This is what the amount is owed. This is what's reflected in the records. But the records don't get introduced into the evidence. Okay? Not saying that was good. Not saying the lawyer shouldn't have done that. But that was the error. Trial court usually overrules an objection based on hearsay. The trial lawyer proceeds. All of the cases that are cited by the petitioner in their papers, and this is the line, they involve more of a pure sufficiency of evidence issue, okay? And let me explain. I'll start with the cases that are farthest away.
Insufficiency that's not induced by a judicial error.
I think that's correct. Now, there are some cases that are close, and these are matters of degrees, and this gets into the fact-specific issues. And if I can, I want to talk about the most extreme cases, and then I'll get to your cases, if I may, if that's okay, and discuss that issue, because I think that's the rub. So the cases that they cite in their papers, there are a set of cases that are very far away. It's the Levy case, the Tika case, the Pain Care case. These don't even involve admissibility of evidence issues and an erroneous ruling by the trial court. These involve cases that are basically the correct calculation of damages, right? And where the evidence was submitted for the correct calculation of damages. So you have a trial court, or excuse me, the appellate court says you have a conversion claim, for example. Appellate court says correct measure of damages in a conversion claim is the fair market value of the good at the time it was converted. But at trial, all they did was introduce evidence of lost profits, right? So no evidence with regards to the correct measure of damages. So that's qualitatively different than a case where you've got a witness on the stand, the witness testifies based on business records that this is the amount that's owed, they don't introduce the records. There's something there, right? There's sort of that some evidence rule. There's something there in which we can do justice and we can decide this case on the merits as opposed to the other. There's another set of cases. This is the Tracy case, which they cite. This is also, I believe, the Morales case. These don't even involve admissibility of evidence. These involve pleading issues, whether or not the trial court properly amended the pleadings at trial to conform to the evidence, or in the Morales case, whether or not the evidence even conformed to what they originally pled. So in that case, they pled an adjustable rate mortgage at a higher interest rate. The witness gets on the stand, says, no, there's a loan modification with a fixed rate mortgage, okay? Comes down to the trial court, says, do you want to conform your pleadings to this evidence? And the trial lawyer says, no, I'm proceeding on the adjustable rate mortgage, right? So there's no evidence that supports the pleading. Again, qualitatively different from our case, and you can see that that's a sufficiency of evidence case that's closer to an involuntary dismissal. Now, the closer cases are, for example, the Wolkoff case, right, and the Mace case. And these are closer to your issue. And so what happened in the Wolkoff case? These are the two cases that are in the Second District, the sort of diametrically opposed cases. And I think our court followed the correct case, which is Saas, which is witness testifies on business records, and they're not admitted. What happened in Wolkoff? Wolkoff, they put on a witness. The witness didn't have any personal knowledge, but the witness also didn't testify from business records. What they did was they handed the witness a proposed final judgment drafted by the bank's lawyers. They said, do the numbers in that judgment look accurate? He says, yeah, they look accurate. Doesn't testify from business records, doesn't even really testify to the amount. Okay? So you can see that that's more of a pure sufficiency of evidence. His testimony is not based on records or something that if we got into evidence would be admissible and would be viable. It's just based on this proposed final judgment. They didn't even submit records to even support that judgment, okay? The Mace case is another one. This is the closest one, but this is still
Now, the
distinguishable.
last case you're talking about is the second DCA case, right?
Wolkoff, that's correct. And in the second
So
district.
that's not a conflict.
Right.
No, that's not a conflict. And that goes back to the question of, is there really truly a conflict? And did the second district's decision conflict with anything of its own court? No, it followed SAS, which I think that it's on 4 squares. And these other cases from the other districts, which also follow that business.
Could we go to Figueroa?
I'm sorry?
Figueroa versus Federal National Mortgage Association, which is the 5th DCA case, 2015. That seems pretty close factually to this one.
I'm sorry, which case is that?
Figueroa, it's 180 Southern 3rd, 1110. It's a 2015 5th DCA case. The plaintiff there, I think so. I think the plaintiff there produced one witness to confirm that the foreclosure amount was consistent with the loan records. Stated differently, isn't the rule different in the 5th DCA than it is in the second? Doesn't everyone sort of concede that while it may not be an express and direct conflict, one might expect this case to come out differently, or the 3rd or the 5th? I think we can pick our favorites as to which is closest.
Again, they're fact-specific issues, and I apologize. I'm pretty sure I read all the cases that they cited in their brief, so I apologize. There's obviously thousands of cases out there, and it's impossible to read all of them. I try to focus on the cases that are in front of us. There's a case that we cite from the 5th, this Webster case. There are other cases. I don't believe there's a conflict in this decision on the 4 squares with the facts. The Webster case, for example, is very similar out of the 5th, and in that case, again, just like our case, the witness testified based on business records. Those, in fact, were business records of the prior lender, just like in our case, and they just didn't introduce the records. They remanded for further proceedings. So I'm not quite sure exactly on those facts, so I apologize. I'm embarrassed that I can't directly answer that question. But I do feel if we go back and look at the cases that we've cited, there is this line. And so I wanted to address this last case, which is the Mace case. And so in Mace, the issue in there was whether or not the bank satisfied a condition precedent by mailing the default notice. Okay, so the issue was the evidence of whether or not the default notice was mailed. They put on the witness had no knowledge whatsoever about the mailing, didn't mail the letter, nothing. There were no business records for the witness to testify on. The only record was a certified mail receipt that they couldn't even link to the letter and didn't even show that the letter was mailed. So the witness's testimony was entirely, well, I spoke to somebody and somebody said they thought they mailed the letter. Okay? So in that case, again, it's a little bit farther afield and more qualitatively different. It touches on the question of evidence and admissibility, but it's not based on anything that's really legitimate, right? It's based on hearsay, as opposed to being based on business records, where if we could go back, we can put those business records into evidence, and we could cure this issue, and we can get closer to the issue of deciding the case on merits.
I'm sorry to interrupt you. So this would make a great law review article.
If you have some time, we'll sit down and...
To the extent that we have to try to write an opinion, if we get past the conflict issue, which I don't know that it can be gotten past.
I would...
But if we accept the existing doctrinal framework, it seems like from what I've seen, you have statements of a general rule and followed by, unless there are exceptional circumstances, right? The general rule being you remand for dismissal unless there are exceptional circumstances. So one path would be to say that this is an exceptional circumstance, which seems like that might be a stretch. The other path would be the 3rd DCA, which I know has referred to this concept of judicial error, which Justice Kennedy also referred to. Do you think that doctrinally this type of thing would fit into that bucket of the type of judicial error or a judicial error that we would fit within that? I mean,
Right.
The third approach would be to just say forget about trying to articulate these general rules. We're just going to announce that in a situation where there's, someone's testifying about business records, there's an objection, it's overruled, and then it's reversed on appeal, that you get a second bite in that situation. But if we're going to stick within the categories as they exist, either judicial error or exceptional circumstance, do you think this fits within one of those?
I do, but this is how I would answer your question respectfully. So the rule could be as simple as the business records rule, as you testify to, but I don't think that's the rule. I like the idea that I've tried to articulate, that we want to sort of balance finality against deciding the case.
But that's not a rule. I mean, that's
I
because
understand.
it's finality, it's merits, but it's also this sense of there's some kind of fairness issue, whether it would be unfair to the
that's
person.
what I agree with that 100%. So what's articulated in our brief is, yes, in Tracy they talk about exceptional circumstances, but what does that mean, right? The guiding principles that we see in Tracy case, we see in a whole bunch of cases, and even going back to this court in the Chapman case, the only Supreme Court precedent that's been cited in either one of these briefs was cited by us. The Chapman case, it talks about interests of justice, okay? It goes back to 1933, and none of us were alive.
Back when they used to talk about justice, unironically.
Well, I'm going to shock my mother. I'm going to say sometimes our elders are right. My mother would be very shocked for me to say that, but sometimes they're right. And so I think we should subscribe to trying doing the principle, the guiding principles being interest and justice, right? And how do we do that, and what do we look at? And I see my light is on.
Yeah,
Can I finish answering your question?
It sounds like you're about to go down another very abstract path. Why don't you take 30 seconds to finish up?
I would like to answer your question if I can. So there are cases that we've cited in our papers. There's the sort of some evidence, no evidence rule paper we've cited to, in which there's something we can hinge our hat on. There are also the cases that talk about the erroneous ruling of the trial court, and I think those cases also have merit. Those cases say, look, the trial lawyer should not be put in a worse situation here on appeal than if they had sustained the objection, then that trial lawyer could make different moves and put in different evidence, right? I don't believe either rule should be a bright line rule. I think they are justifications and policy decisions that lead us to more fact-specific decisions that accord with interests of justice, equity, and fairness.
Okay,
So,
thank you
very much for your time. I'm sorry I went over. Thank you.
And Your Honors, to address, I think, a critical component is the issue of whether or not there was a fair trial below. And there's a critical question as to whether or not the decision not to put on any competent evidence. And here, to the extent we're looking at that some evidence, no evidence standard, this is, I think, closest to Wolkoff. We have no competent witness to testify, and we have no documentary evidence. Because this was a Zoom hearing, it is even more clear in this case than in nearly any other context that this was exactly the trial that ICAP wanted. In order to present documentary evidence to the trial court, it would have to have presented proposed exhibits in advance of the hearing that it set. It itself set. This is not a case where there was a gotcha, the judge set the trial date for them. They, for reasons of their own, failed to tender any evidence in advance, no proposed exhibits in advance. I think that the First District Court of Appeal got this rightest in Evans versus Delro, which is dealt with in the case, or dealt with in brief, which is specifically, we anticipate, to paraphrase, we anticipate that if somebody has a trial, they put on their trial. They give it their best shot. If they have evidence, they put it forward. And any assumption other than that would lead to chaos. And that's exactly the situation here. I've heard many references to the concept of equity and justice. Here, there was a perfectly fair case. There was the case that ICAP crafted, ICAP created, ICAP drove. They got their day in court. They failed to make their case. They failed to demonstrate that they were entitled to damages. They failed to prove their standing in the matter. There's nothing about this case, about the facts of this case, that would indicate that another bite at the apple is somehow appropriate, is somehow permitted. If it's permitted in this case, where strategic choices were demonstrably made not to put on an entire case, then I can't imagine the circumstances where a dismissal would be appropriate.
What strategic, I've been trying to understand what strategic advantage they gained by making this decision. Can you articulate what you think it was?
Your Honor, I believe it was to prevent, well, one, to the extent any other evidence exists, we don't know what that is. But to the extent that this was a benefit to the plaintiff in this case, they were able to present a witness that we had never heard of. We had never seen a document that demonstrated that he was a part of the purported plaintiff. We've never had the opportunity to review the original.
I get that with respect to putting on Geigel.
Sure.
My question is, your briefing suggests that they made a tactical decision not to put in the documentary evidence of the amount due. I don't understand what strategic purpose that serves. Do you?
Your Honor, I believe that any actual tendering of the evidence would have demonstrated that the records on which they relied were either incomplete or irreconcilable with the actual reality. I don't know that they have received, in fact, a complete record from any predecessor that was either a lender or a loan servicer. There's testimony that they got something. We have no idea what it was. If what they received was incomplete, if what they received demonstrates that, in fact, the principal amount is substantially lower than they anticipated, then there would be no benefit to tendering that evidence. If they can put forward, and we have some evidence, that they saw multiple numbers as to what the principal amount was. None of the principal amounts testified to by Mr. Geigel matched the principal amount in the complaint itself. And so to the extent all of these were inconsistent with one another, to the extent that they were not reliable, that they were not trustworthy documents, then it would not have been in their best interest strategically to place them in the record for an appropriate examination. And with that, I see my time is expiring. We also would rely on the brief for purposes of the usury analysis, Your Honors. This Court's review is plenary once discretion has been accepted, and so we would request, to the extent that there is any permission for an additional, excuse me, I see my time has expired. We would request remand with instructions for dismissal. Thank you.
Thank you. We'll be in recess for 10 minutes.
All rise. All rise. The Florida Supreme Court is back in session. Please be seated.
Our next case is Worrell versus DeSantis, number 23-1246. Counsel.
Mr. Chief Justice, and may it please the court, my name is Laura Ferguson, and I'm arguing on behalf of petitioner Monique Worrell. Governor DeSantis' suspension of Ms. Worrell exceeded his authority under Article 4, Section 7A of the Constitution because the order does not allege any conduct by Ms. Worrell that, even if proven at a Senate trial, would constitute neglect of duty or incompetence. State attorneys are constitutional officers. They are elected to serve as the prosecutors in their circuit. They are invested with substantial discretion and independence and are subject to limited supervision even by the state attorney general. They are accountable to the voters, and because they are elected and not appointed, they do not serve at the discretion of the governor. Under the Constitution, the governor's suspension power is limited to specified grounds, all of which entail egregious misconduct. For this reason, historically, most suspension orders have involved officials who have committed a crime or presented a grave threat to public safety. Removing a state attorney because of disagreements over the lawful exercise of prosecutorial discretion is unprecedented. While this court has treated blanket non-prosecution policies as an abuse of discretion, no blanket non-prosecution policies are alleged here. The governor is, of course, entitled to have different opinions as to how Ms. Worrell should exercise her discretion. He's entitled to endorse her political opponents. But short of conduct that meets the high bar for suspension, it is the voters, not the governor, to whom Ms. Worrell is accountable.
Counsel, can I ask you why, either textually or in a historically informed sense, if assuming it's kind of all of our precedents about how deferential this phase of review is, why is the concept of neglect of duty not broad enough in its broadest but still reasonable sense? Why isn't it broad enough to encompass the kind of things that are talked about in the suspension order here?
Well, first, we should look to the definition of neglect of duty that was in place during the most recent iteration of 7A, and historically has been the definition. And it entails the failure on the part of a public officer to do and perform some duty or duties laid on him as such by virtue of his office or which is required of him by law. And then more recently in Israel versus DeSantis, the court defined neglect of duty as neglecting an action required by one's position or occupation. So here I think what's critical is that there is no duty that Ms. Worrell is alleged to have neglected. Her duty as a prosecutor is to exercise her discretion within the bounds of the law and to look at each case on an individualized basis. So the executive order, for example, in the case of Andrew Warren, alleged that Mr. Warren had abused his discretion because he'd essentially abdicated his discretion. He wasn't deciding cases on an individualized basis. He had categories as to which he said there would be no prosecution. Mrs. Worrell doesn't have categories of non-prosecution. She's looking at each case on an individualized basis, and that is her duty.
That's not what's alleged, though. I mean, basically what's alleged, to kind of sum it up, is that she has policies that under-prosecute certain categories, and that she does not, it's not that she got a categorical rule that you'll never prosecute anything in that category, but there's a directive, an understanding that we really aren't going to focus on these cases. And I think that's a rough paraphrase of what's in the order, but that's kind of the drift of it. Wouldn't you agree?
The order infers and speculates about policies.
Well, it makes assertions. It makes assertions. I
But-
mean,
but
it makes allegations, okay? And it doesn't have to prove it. I mean, we know that's what the trial and the Senate's for. But it makes those assertions, which may or not be warranted. That's not for us to figure out. I mean, you would admit that. We don't make factual determinations.
I agree you don't make factual determinations, but let's pick a policy that the order speculates Mrs. Laurel has, that she discourages line attorneys in her office from seeking certain sentencing enhancements. So even if that's true, it's not a neglect of duty for a prosecutor to do that because the statutes themselves.
Why would there not be an understanding of neglect of duty, or an understanding of duty, where that would be a neglect of it? That seems to me. Then you're getting into really that's kind of a political question. It seems like to me the scope of how the duty is understood. And how that's going to be defined, it seems to me to be, reasonable people can disagree about that, but the governor and the Senate have a constitutional responsibility to make determinations about what falls within the scope of neglect of duty, and under our precedents, we don't get into that unless it's something just like totally unrelated.
Well, this court has recognized its role in determining whether the suspension order is within the constitutional authority of the governor and to ensure that that order is not abusing that power. And as Justice Lubarga has noted, that the court's role is not pro forma, and this is especially important where you have an elected official. And yes, there are ranges of views about how best to secure the safety of a community, how best to use law enforcement resources, but generally we leave that for the voters to decide.
Counsel, can I just take you to a specific example? I'm going to page 7 of the order, the first full paragraph, which says that it alleges, this is an allegation, that assistant state attorneys are generally prevented or discouraged from direct filing cases whereby juveniles are charged as adults and are encouraged to effectively drop charges against juvenile defendants. That doesn't seem to me to be inferential. That doesn't seem to me to be an exercise of discretion. That seems to me to be a fairly concrete allegation. Now, it's not proven, but how do you address that specific allegation and tell us that that allegation, if proven true, would not constitute malfeasance, misfeasance, or neglect of duty?
Because the decision whether to direct file a juvenile is by statute, within the discretion of the prosecutor.
You believe the statute would give her the ability to prevent. It doesn't just say discouraged, it says prevent, and then effectively drop charges against juvenile defendants.
So let me just make the sort of fundamental point that the direct file statute was amended in 2019 to end mandatory direct file. So now direct files are entirely within the discretion of the prosecutor's office. So therefore, there is no duty for a prosecutor to direct file individuals. It is within the state attorney's discretion.
You believe the state attorney could legally prevent the filing of charges in some form? Like it just, that strikes me as a pretty clear allegation of a policy, of not an individualized determination. If you prevent something, you're saying it's not going to happen.
If there was a categorical policy that this office will never direct file juveniles, then we're closer to having a neglect of duty. But even the executive order or the briefs acknowledge that Ms. Laurel's office does direct file juveniles. So there is no
But it seems like to me, you say
blanket
if it's not a
policy.
categorical rule, then somehow it can't be a neglect of duty. That just seems to me to be kind of something that would lead to playing games. You say, we're not going to have a policy, wink, wink. We just don't do it very often.
But that is within the state's attorney's discretion. So it's not as though in the federal system the prosecutors are appointed by the head of the executive branch, and everyone has to be aligned on exactly how policies are carried out.
I understand that.
It's an
it is
independent
different.
office.
They are part of the executive branch. However, you would concede.
And also they have a quasi-judicial function as well. They're created under the Article 5 that creates the judicial branch, and they are officers of the court.
They are executive officers.
They are constitutional officers created under Article 5 of the Constitution, but they have a dual function, executive and quasi-judicial.
Well,
Are you suggesting that prosecutors exercise judicial power and it takes them outside of the executive branch somehow?
No, I'm not suggesting that, but they are officers of the court.
I have a question on, wouldn't you agree, though, that a difference in degree can eventually be a difference in kind, right? So you're focused on blanket policy. Let's say that a prosecutor had a policy that they were only going to prosecute 1% of juvenile felonies. In your view, could that constitute neglect of duty?
I think there is in the absence of any statutory requirement that certain categories of juvenile offenses have to be prosecuted, as adults, which the legislature eliminated. They eliminated that mandatory requirement. Then it is within the state's attorney's discretion as how best to ensure the safety of the community.
That would be a fine policy for a prosecutor to have, that they were going to have a policy that only 1% of these juvenile offenses would be direct filed, and it would be some sort of lottery system, which one got picked.
Well, to be clear, that's highly hypothetical. That's not what's alleged here.
We're
not
trying to find out where the lines
policy.
are. Can a difference in degree become a difference in kind and constitute neglect? And if so, who decides?
I mean, absence the showing of some threat to the public that would justify executive interference in the democratic process, I think the system is intended to let the democratic process play out and let the voters decide. So the grounds for suspension are things like malfeasance or commitment of a felony or a complete incompetence. And it's situations where something has arisen after the election that necessitates intervention to protect the public, to protect the operation of the judicial system before the voters, are going to be voting again. Here, there's no emergency.
I'm sorry to interrupt you, but the order does allege that cumulatively all of these things do result in danger to the public. You're raising, obviously, these are very important issues about the proper balance between the governor's authority and local decision-making and all that. I mean, not to minimize any of that. That's very important. But it seems like our role, at least in our precedents, has been limited to having where it's kind of doubly deferential. It's deferential both at the level of defining the possible meanings of the terms in the Constitution in a way that I think essentially if there's any reasonable understanding of the words, because what we're here basically to protect against is the arbitrary exercise of power. So we have deference at the level of interpreting the words, and then we have deference at the level of what kind of factual allegations are reasonably related to that very capacious definition or understanding of possible meanings of the words. And so, it seems like unless we think that the only reasonable way to interpret the language is neglect of duty means literally just not doing, not showing up for work, or saying, we're going to identify these 8 types of crimes and just per se not prosecute them. It seems like we have to allow for the possibility that if you do your job, again, allegedly, we're not here to litigate the facts, but if you allegedly do your job so poorly and as a result of these decisions that you've made in terms of your policies and practices that they endanger the public, that then you move into the realm of having to argue to the Senate that, these other, either that that's not true or that the local control kind of predominates over that.
Here, the executive order does not identify conduct of Ms. Laurel. It doesn't identify policies in any concrete sense, unlike the executive orders at issue with State Attorney Aramis Ayala or Andrew Warren. In all the other executive orders that this court has looked at, it's been very clear exactly what the state official did that was problematic.
I'm just not
we
sure.
know from Israel. We know
don't-
from
I don't know
Jackson.
how you can I got another one for you. Look at page 12. Whereas under Worrell's supervision, her subordinates have authorized or required assistant state attorneys in the Ninth Circuit to seek the withholding of adjudication in cases where such disposition is not permitted by Florida law. So just grabbing from that sentence, under her supervision, her subordinates have required ASAs to seek the withholding of adjudication where it's not permitted by law. That sounds like an allegation of illegal conduct, no?
Well, there's a couple layers to this. First, it's alleging that her subordinates have permitted.
No.
So that's like,
Yeah.
so
She's
it's
or
not about
required
her,
them, or required them.
her subordinates, not her, right? So, and there's been
Well,
a
she's the
lot
elected
of
official. I mean, that's the whole thesis of your argument, right? Buck
Right, but
stops
there's
with
no
her.
allegation that she's been derelict in her duty of supervision.
Well, I
her
would think that
subordinates.
if her subordinates were giving these orders and she was unaware of them, then she would be derelict of her duties, right?
And not necessarily, right? It's a large, busy office to neglect to suspend a state attorney for, an isolated instance by one of the line prosecutors would make any state attorney
I guess my
vulnerable
point
to
is,
suspension.
These are triable issues, and this is an allegation.
but
I don't know
I
how
just-
you can look at this and then say there's no allegation of conduct that would be violative of law.
What
It says-
duty is neglected here? Because the statute itself on withholds of adjudication, it says that if a state attorney is to, that a state attorney generally has some discretion to seek withholds. There are certain situations where, there's been a repeat offense where the judge is not permitted to issue withholds of adjudication. This order does not provide a single example where Ms. Worrell or someone in her office requested a withhold where it wasn't statutorily authorized. So again, it's unlike any other suspension order where we know exactly what the officer did in Hardy.
Counsel,
v.
before your
Coleman.
time runs out, and I'm sorry to cut you off, I want you to respond to the argument from the other side, specifically that we essentially lack jurisdiction because the issues raised by Ms. Worrell are non-justiciable political questions. Can you respond to that, please?
Your Honor, it is this court's role to interpret the Constitution. That role is vested in this branch, and we are just asking the court to interpret the Constitution and determine whether the governor has exceeded the scope of his authority under the Constitution. That is traditionally within the realm of the court. And even the Senate itself does not treat this court's role as interfering with its role. Its rules contemplate that there will be, can be judicial review, and they will hold their proceedings in abeyance.
Well, I have a
There's
follow-up
been-
to that question. So the follow-up question is, can you tell me, are there any cases that you can cite where a Florida court has considered the political question doctrine that makes suspension non-justiciable?
Well, at the landmark
ever
leading,
decided it
yeah, in
at
the
this level
landmark,
or-
yeah,
yeah,
at the
in
leading
Florida?
landmark case, Hardy v. Coleman, the court looked at the separation of powers issues and distinguished case Myers, where there was, an issue that was exclusively delegated to a particular branch, and said, well, suspension is different because already we have a blurring of which branches are involved. We have suspension with the executive. We have the removal or reinstatement with the Senate. So the separation of powers concerns are already not really sort of incorporated into the system. But in any event, there's no textually demonstrable commitment of the review of the suspension issue, to the executive. There's no language giving the executive sole power to determine the constitutionality of the executive's action, right? I mean, the impeachment cases on which the governor relies involved language saying that the Senate has sole power to try impeachment. So, of course, the court could not interfere with that. Or in McPherson versus Flynn, the Constitution says that the legislature is the sole judge of the legislature's qualifications. We don't have any language like that, and this court has always carefully walked the line between what its role would be in reviewing the suspension versus what the Senate's role is as weighing the evidence. And at this point, unless there's further questions, I'll reserve my time for rebuttal.
Just
Yes.
a question on the duty. Obviously, the Florida Constitution requires that constitutional officers, including prosecutors, take an oath to uphold the Florida and the United States Constitution. There's a clear separation of powers provision in the Constitution. The veto power is the governor's in the Constitution. So when we're looking at being neglectful of duty, why can we not consider the context in which prosecutors operate when considering whether or not a blanket policy or a almost blanket policy constitutes neglect of duty?
Well, to be clear, there is no blanket policy or almost blanket policy, but I think inherent in the operation of the criminal justice system is the independence and the discretion of prosecutors. And if a governor were able to remove a prosecutor of a different political party simply because they disagree with their policies and categorize that as neglect of duty or incompetence, then that will have a substantial chilling effect on how state attorneys perform their roles or their willingness to serve.
Thanks. You can have 2 minutes for rebuttal.
Thank you.
Mr. Chief Justice, and may it please the court. The governor properly suspended Ms. Worrell from office because of practices or policies that she adopted as state attorney that contravened legislative policies and simultaneously resulted in the gross underperformance of her office relative to all other state attorneys in the state. We think that, of course, that policy judgment is not properly in front of the court. At most, your precedents say you'll ask whether there is some reasonable relation between the facts alleged and the neglect of duty and incompetence. As I think many of the questions this morning have hinted at, on these facts, that is somewhat of an easy question. And so I'd like to talk this morning, if I could, I'm happy to talk about any part of the case, but I'd like to start at least with our argument that the entirety of Ms. Worrell's petition presents a non-justiciable political question.
Before you get to that, can I ask you about the policies and practices issue?
Of course.
How much work is that doing in the order, in the sense that I guess I'm curious if you thought it was necessary to allege that as opposed to just putting in a bunch of stats about how in the governor's view, you know, the state attorney is just not protecting the public, you know, at a level that reaches duty. And are you planning on actually proving specific policies? And I don't know what exactly a practice is, but, you know, what is the role of that allegation in the order?
I think that they all work together, but they also work independently. And so if we had no allegations at all about practices or policies, and it just turned out that Ms. Worrell was not very effective at prosecuting crime, and the data, you know, I think does prove that. I'm happy to talk about that in sort of granular detail. But if we had nothing else than the data, I would think that would be enough. Now, the practices and policies make that even stronger, and some of the questions have gotten at, you know, exactly the ways in which these policies are improper and frustrate things like the legislature's zero tolerance policy. It wants there to be these minimum mandatory sentences for individuals who commit drug trafficking and firearm offenses. And Ms. Worrell's answer on some of those points, if you look at page 41 of the petition, with respect to the firearm minimum mandatories, she says, well, you know, there's nothing in those statutes that prevents me from sort of evading the min-mans by downcharging. And so if I had a robbery with a firearm case that I knew that I could prove, the suggestion is that she would downcharge that and plead out just to a robbery without the firearm to evade the min-man. And I do not think that that could possibly be what the legislature had in mind when it said zero tolerance and you must impose these certain minimums. But again, you know, if there was nothing else and we just had the data, and what some of that data shows, take the prison admissions for 2022 to 23. So if this is, you know, 100% of the prison admissions statewide, she was at 38% of those. I mean, that really is an abysmal record. And if we had nothing else, if there was nothing specific she was doing, she just was not effective at prosecuting crime, we think that that would be enough.
Let me ask this. We recently had a case before us where this happened. Let's say there's a inner city type of crime where there's a drive-by shooting and a young girl gets shot. Only one witness saw it. And state filed charges based on that one witness who saw who shot. Sure enough, as it can be expected in many of those cases, later on in the case, depositions come around, the witness suddenly couldn't remember. Now the state is left with nothing. He had the case charged with a firearm, which obviously aggravated the penalty. In that case, the state is faced now with either offer something in way of a plea, get something from this guy, a few years in prison, whatever, or just take it to trial and surely result in a not guilty or a directed verdict, a judgment of acquittal by the judge. So, Arnie, what we're doing here today, placing a chilling effect on prosecutors for making the decision, let me take something, let me eat the gun, meaning take that out of the sentencing process, and let's offer this guy 2 or 3 years in prison, at least get that out of it, or I better go ahead and just take it to trial and just fly the airplane against the mountain, because if I don't do that, the governor's going to fire me. Isn't that what we're doing in major metropolitan area where we get many, many, many of those cases?
So I don't think so, Justice Labarga, and I recall that case very well. I think, you know, what you are describing would be a valid exercise of prosecutorial discretion.
Well, who decides that? I mean, do prosecutors have to call the governor and say, or the governor's general counsel, whoever, and say, look, this is what I need to do here. Is that okay with you, Governor? You know, who decides that?
And we're, of course, not saying that. I would say a couple of things. Number one, the Hardy versus Allen case from 1937, I do think stands for the proposition. That was the gambling case. I do think stands for the proposition that the label prosecutorial discretion doesn't insulate a state attorney from suspension for neglect of duty. That was a case in which it was not a blanket policy case. There had been gambling prosecutions brought by that county solicitor, and the governor decided that there had not been enough and even identified some specific instances that he thought should have been charged. And this court said, applying the applicable quo warranto standard, that that was properly a case that could go to the Senate to decide. And I think that's the real answer, and that's part of why we believe that this is non-justiciable, because the check and balance in that circumstance is a political one. Not only the fact that the people elected the governor and he is accountable to them, but also because the Constitution, the people themselves, set up the Senate as effectively performing the judicial review of a suspension order.
So, counsel, what would this court's role be? How do you square that? Let's say we agree with you that this does present a non-justiciable political question. What is the court's role in issuing these writs of quo warranto?
Justice Francis, you know, we would draw the line much in the same way that you proposed to do so in your concurring opinion in the Warren case, which is to say that you could identify some very specific, you know, straight up or down, yes or no type of questions where you have a judicially manageable standard, and those the courts could address. And so, for instance, if the governor attempted to remove, and this of course would never happen, if the governor attempted to remove an official who was subject to impeachment rather than suspension, I think you have a clear judicially manageable standard to say we can step in and adjudicate that case. I also think that along the lines of the concurrence, you might say something like, is there a written order that states grounds and that is filed with the state custodian of record? That would be justiciable because of the presence of judicially manageable standards. The problem is, and this is the difference as we understand it between our view of the political question doctrine and the reasonable relation test that you apply now, is because there is at least some argument that a claimant could make that the stated grounds do not have that nexus. And as soon as you get into doing that sort of inquiry, you do have to think to yourself, well, what do I believe that a neglect of duty for an executive branch official would look like in this context? And even if you are deferential about that, you are still exercising a political judgment call about what conceivably that neglect of duty could be.
Don't you think we could look at what a reasonable view of that would be? That's not necessarily I mean, judges do that all the time. People do that all the time. We look at what a reasonable view would that be, and we're highly deferential. Why would that preclude review altogether, because we have to consider reasonableness as part of the analysis?
Well, I think, Justice Grosshands, If the standard really is that deferential, then you probably get to the same place in a lot of these cases anyways. And the fact of the matter is you have not been quashing these suspension orders under the reasonable relation test. But part of the problem is that it always invites litigation. So even though you have laid out this very deferential test, and it's been the rule for decades, we still end up with pages and pages of briefing on things like, what do the facts show? What does the evidence show?
Well, how would you reconcile, your political question doctrine and this idea that this whole area is non-justiciable with the Section 21, Article 1, access to courts, that courts shall be open to every person for redress of any injury? I mean, that's just as much a provision of the Constitution as what you're citing to say, no, actually, in this case, the courthouse is completely closed. No one could raise this question here.
Well, and to be clear, I do think that there would be some judicial review. It's just you would perform that review where you thought that there was a judicially manageable standard. The second thing I would say about that is that the political question doctrine just sort of bakes in that idea, and I suppose the same thing could have been said in the Citizens for Strong Schools case, where the question was, does adequacy or high quality have some kind of judicially manageable content? And the court said no, and thus the courts had to be closed in at least that limited respect. But that does seem to be the way that the U.S. Supreme Court has analyzed these questions. It said in cases like Baker versus Carr, there are no political cases, there are just political questions. And so you really do look to see what are the claims, and is this the type of claim that would be appropriate for judicial resolution?
But I think these are terms that are, if you look at the overall context, the voters chose not to say, the governor can remove state attorneys for cause, or if the governor thinks, he or she, the governor thinks the state attorney is doing a bad job. They chose kind of legally recognized terms with a long history. The person is elected, they do have certain interests / rights and, their job, et cetera, et cetera. And so, unless, if we think that the Senate, if what they're doing is kind of a substitute for a, trial-like thing, they're applying real standards. I mean, I don't think that there's anything that's inherently kind of unmanageable about the terms. Obviously, you'd have to ask yourself, and I think the court has sort of thoughtfully over time developed this very deferential understanding of what that is. But, I don't think that it's something where it's just, when you see it level subjectivity. Otherwise, the whole thing doesn't make any sense.
Well, just to give you an example about the kinds of interminable line drawing that you'd be required to get into if you were to do this type of review, I think everyone would agree, if you just, going back to to prison admissions, if the allegation was that a state attorney only obtained 5% of the prison admissions that everybody else throughout the state obtained, we would say that's a really easy case. Of course, that person was neglecting their duty. This case is 38%. That also seems like an easy case. But if you get to 65 or 70 or 75%, I think you could see how it might be a little bit more of a difficult question to say, yeah, we think that side of the line is neglect of duty, that side is not. And so, I do think that's where the use of political judgment comes in, because
why isn't it, why isn't it more less a question of judicially manageable standards and more a question of what the proper scope of Quaranto review is? And so I don't see it as us trying to land on where or not there's a judicially manageable standard so much as we have the constitutional authority to hear petitions of writ Quaranto. What is the proper scope and whether or not our case law has stayed within that scope. So if that's the framework, then for something like neglect of duty, let's say there's an executive order that, somebody, a constitutional officer says on Facebook, like, oh, I was super neglectful, I burnt the casserole, that's appended to the executive order. Would Quaranto be broad enough for a court to look at that and say, the governor does not have the authority to suspend for negligent baking of casseroles, for example?
So I think if suspension cases under Article 4, Section 7 were the entire universe of quo warranto cases, that might be more palatable. But the fact of the matter is quo warranto has all sorts of applications. Setting aside the governor's suspension power, that power is just one particular application of the writ. And so I think a big part of our argument here is that there are clear textual commitments to the Senate, and this court has said this, that like in Israel and Coleman, that the Senate itself is the court that the people set up to decide these questions. And so I think to some extent that displaces the more generalized quo warranto authority that you would have to get into in detail and judge the sort of sufficiency of the factual assertions.
Can we talk about precedent, though? Because it seems like Allen, this is a difficult issue, I think, that they wrestled with. They wrestled with the textual allocations of who's doing what. They wrestled with the idea of the individual's, right. Judicial power is about enforcing individual rights. This removal thing, it's not even a trial referred to textually the way impeachment is. They came up with what I think is a very thoughtful resolution of it. You had opinions that ran the gamut. Buford's opinion is essentially kind of anticipated your argument 90 years ago. They didn't use the term political question, but he makes all the same arguments. He says, I'm not even going to participate because we don't have jurisdiction, and here's why. Fast forward 30-something years later, the voters adopt a new constitution. They don't say anything to kind of fix this by adding words like soul or telling the courts to butt out of it. Why would we not accept that resolution that's been part of our constitutional history now for 90-something years, other than maybe just this kind of, well, you're wasting your, everybody's time with these things because it's so deferential that the court, ends up saying that it's all within the zone of reasonableness. I mean, I don't understand why we would make some pronouncement about justiciability and not having jurisdiction, et cetera, when it's such a well-established thing and where it's, hardly obvious on the merits.
Well, it's certainly not obvious to the quo warranto petitioners themselves because they come to you time and time again and they make these arguments. But look, I mean, if where you end up getting to is effectively the same place because you clarify that the reasonable relation test truly is this deferential, I think that solves many of the concerns. But, all I'll say is that the logic that the court espoused in adopting that test does not quite match up with the end product because you still end up with a test that has the judiciary sort of making, in some sense, these kinds of difficult policy decisions. And I think as a matter of doctrine, the correct answer is that this is non-justiciable.
But why is it, it's not to say, I mean, it's kind of bread and butter judicial job, it's part of the job to interpret words and to identify kind of reasonable, not necessarily, I think this is clearly an area where the court has not said, we're looking for the best meaning of the text. We're looking for, they're trying to establish what could a reasonable person think neglect of duty is or misfeasance is or whatever. And that's core, I mean, that's our bread and butter. That's what we do every day. So that it's not like we're, being asked to say what's the optimal amount of money to spend on textbooks in schools or something. So I just don't understand. I mean, the notion that we're somehow at sea and this is so subjective, et cetera, we've never claimed the authority to say definitively this is what the word means, and all we're looking for is evidence that might support it. We've always allowed a zone of reasonableness, even into the definition of the phrases in the Constitution.
Well, I do think that and you raise fair points. I think that maybe some clarification to the public at large about what the standard looks like might be helpful here, just because we end up making these same sort of fact-bound, arguing about the evidence in all of these cases, it seems like, and so maybe the message hasn't quite gotten across. But, I guess the only thing I would say with respect to the precedents is that the modern political question doctrine really didn't come along in its current iteration until the 60s with Baker versus Carr. And as to whether there's been any change to the text of the Florida Constitution from the 1885 version to the modern Constitution, Article 4, Section 7, the one thing I'd point out is that there has been a slight textual change, which is that before the Senate didn't have the power to reinstate. It sort of de facto did if it didn't act or if it decided not to remove, but it now has the power to reinstate. I do think it's telling that there are only two governmental entities listed in Article 4, Section 7 with the power to reinstate, which is the governor himself and the Senate. And that reinstatement power really does look quite a lot like a form of judicial.
Let me ask you this. Assuming that the court adopts your non-justiciable political question doctrine in this case and in other cases like it, does that leave the Florida judiciary with any role at all in these cases?
Yes, and so for instance, if the governor were to, attempt to suspend the Speaker of the House, I think you would step in and you would say that is an ultra vires action, which does not even arguably fall within the governor's power, and quo warranto would be appropriate there. But you would look for those kinds of very concrete, judicially manageable standards.
Kind of like what we have in citizens' initiatives, where we just look at whether or not the summary has 75 words instead of 78 and that kind of thing.
Right.
Something that.
Right.
I think there's a lot of people who'd say we do a lot more than that in that area. But
I
with respect to that one question about counting words, yes.
So in no scenario would this be a dismissal with prejudice or dismissal for lack of jurisdiction then? Because it is presented to us as a petition for quo warranto. We conceivably have at least the ability to review whether or not the governor had the authority to suspend, whether or not the prosecutor was a constitutional officer, that sort of thing.
Well, I think what Baker is saying is that you look at the nature of the claim. So you wouldn't say the whole categories of cases is non-justiciable. You would look to see what type of claim did you bring. And so if the claim being brought lacked judicially manageable standards, you would say, we dismiss for lack of jurisdiction. If the claim that had been brought was some concrete judicially manageable issue, like was there a written suspension order at all, then I think you would say we have jurisdiction and we'll adjudicate that.
did you say Baker? Like Baker versus Carr?
Right.
So we're going to, instead of just following 90 years of Florida precedent, we're going to try to figure out how Baker versus Carr should apply to this?
No. I was simply saying that that's how the U.S. Supreme Court, at least, has understood the political question doctrine. You sort of go issue by issue, not just like category of cases by category of case. So that's all that I meant to suggest. And of course, the court has, in many ways, modeled its modern political question jurisprudence on what the U.S. Supreme Court has done. But thank you very much for your time. We think that the case should be dismissed or denied.
Thank you.
It's remarkable that the governor's lead argument is that this court cannot review whether his order is constitutional. And this is a governor who has used the suspension order with great frequency in an unprecedented way and targeted at those of a different political party. So I do think this is a case, Chief Justice Muniz, where there should be some scrutiny of whether there's an abuse of the power. And in terms of whether the court has previously recognized that prosecutorial discretion is fair game and Hardy versus Allen is a non-prosecution case. It's not a prosecutorial discretion case. The reason that the court approved the suspension order was because it interpreted the official as knowingly permitting gambling and preferring no charges therefore. And similarly, the executive order understood Hardy versus Allen as being based on, quote, an alleged unwillingness to prosecute gambling offenses. That's the order at 2. Ms. Worrell does not decline to prosecute any category of offenses. It's even the admissions data shows people have been prosecuted across a range of offenses in her jurisdiction. And in terms of whether the facts alleged are reasonably related to neglect of duty or incompetence, reasonably related is not a standardless test. And what this order predominantly relies on is prison admission data, which is not reasonably related to whether a prosecutor has neglected their duty, because there's a host.
Let me ask, I think the gist of what the court is saying, and the point here is that this executive order is in many ways like an indictment or an information filed in criminal court, where all the state attorney is required to do is minimal allegations that a crime has been committed. And then it's up to a jury to decide whether the person's guilty or not after evidence has been presented. Here, the argument is that this is the same thing. They make the allegations here in the order, and then the Senate will hear the evidence in the case, and the Senate will decide, the jury will decide whether Ms. Worrell is guilty or not of these things. And all those arguments you're making here today will be presented to the Senate, and the Senate will hear it and make a decision. How is that improper?
So the executive order here, unlike an indictment, doesn't identify instances of misconduct of Ms. Worrell. It just speculates that because she ran on a particular platform, she must have certain policies, which they can't identify a single policy. The order talks about how her office discourages, which doesn't sound like a policy. It talks about practices, but can't identify a single example. Practices implies multiple examples. They can't list a single instance where there has been an abuse of discretion. So an indictment tells the defendant, here's specifically what you did, right? And maybe not in great detail, it doesn't have to provide evidence, but this is just speculating. Oh, we see you, state attorney, from a highly densely, populated urban area. Your numbers don't look so good as compared to other circuits where these numbers are about prison admissions, which state attorney, cannot control. There's a host of factors, as you noted, witness availability. Plea bargains are an accepted part of the workings of the criminal justice system. State attorneys are encouraged to plea bargain. There's a host of reasons. The judges control sentencing. Evidence may not be available. There may have been police misconduct. There's a host of reasons that could affect prison admission data. So it is unreasonable to rely on prison admission data to conclude that a state attorney has neglected their duty.
Sorry, you can have 30 seconds to conclude if you'd like.
Just to summarize, the executive order does not identify any concrete conduct, any specific policy, any instances of abuse of discretion by Ms. Worrell that could be considered neglect of duty or incompetence. Instead, clearly there's policy differences, but those are to be resolved in the democratic process through elections. There needs to be some really more egregious, systemic, pervasive problem where there's a demonstrated abuse of discretion to warrant the executive stepping in and removing an elected official. So we ask that you declare the executive order invalid and restore Ms. Worrell to her elected office. Thank you.
Thank you.
My greatest fear.
Okay, our last case today is In Re Uniform Statewide Bond Schedule number 23-1447, Chief Judge Allman. And let me just say, first of all, thank you very much for your service on this work group and the other chief judges who worked with you. We really appreciate it, and I know it was a compressed timetable, so thank you.
Well, we appreciated the opportunity to serve. I really do appreciate that that opportunity. So good morning, members of the Supreme Court. My name is Frank Allman. As stated, I am the Chief Judge here in the Second Judicial Circuit, and I'm here today in my capacity as the chair of the work group on the uniform bond schedule. The work group wants to say that we appreciate the comments that were received in response to the publication of the work group's proposal. After all, we all want the best possible bond schedule. We did meet, we reviewed and discussed the comments, and after reviewing the comments, we do recommend one minor change. Specifically, in the second sentence of the proposal we submitted, we had suggested this bond schedule must be used by the police or county jail or pretrial release employees upon a person's arrest. What we suggest instead is that this bond schedule is designed for use by the police, county jail, or pretrial release employees upon a person's arrest. And the reason for the suggested change is that arrestees do not have the right to release on bond or other conditions prior to seeing a judge for first appearance. Submitting the words "is designed for use" instead of "must be used" is intended to make that clear. In other words, this language clarifies that an arrestee has no right to release prior to seeing a judge for his or her first appearance hearing. However, if the arrestee is permitted to post bond and to be released, the uniform bond schedule tells the jailer or the arresting officer what the amount of bond that is required. We found no authority for the proposition that arrestees do have a right to release on bond prior to first appearance. In fact, just the opposite. In 2022, this court decided the case of Thortman v. Jr., and that's at 338 Southern 3rd, 207. Thortman, candidly, was not a bond issue in the sense that we're here for today. It was more a defendant, dealt with the issue of a defendant being held without bond pending a full Arthur hearing, and whether it was a full Arthur hearing required at first appearance, which would be quite difficult to say the least. But in Thortman, the court stated the right to pretrial release is not lost until a court makes a definitive ruling on the issue of pretrial detention. And additionally, in one of the footnotes, footnote 7 specifically, this court stated, while defendants typically have no right to release prior to first appearance, a defendant may be able to obtain pretrial release prior to first appearance if a standard bond schedule is followed in the jurisdiction of the crime and the arrest. So it seems clear that release on bond prior to first appearance is a matter of grace and not a matter of right.
Judge Allman,
yes.
Could I interrupt you? I'm
Yes.
sorry. I just want to make sure we have time for this. The workforce seemed to have several places where it expressed some concerns about the impact that this would have, both financially and in just management. For instance, how much bigger will the first appearance dockets be? What impact will that have on a system that's already have issues with time and numbers? At what level of concern does the workforce have? I mean, you're the chief of a busy circuit. I mean, what concerns do you have that you could kind of elaborate on in those regards?
I would say a fair amount of concern. One of our workroom members who works in a large circuit in the 9th had her staff look at a year's worth of first appearance dockets and how this proposed uniform bond schedule statute would affect that. And this particular chief judge, her staff came back and said it would cause a 25% increase in the amount of cases that were required first appearance. One of the big changes is all second-degree felonies now require first appearance. That's not the way it is now. The statute carves out a number of other violations of criminal law that require first appearance, but now in addition to all the other things that require second-degree felonies. And so it's a fair concern. We didn't do the chapter and verse study in our particular circuit, but our first appearance dockets are already fairly crowded. To address what I think you may be asking next is about the research required to determine whether a particular arrestee is even qualified under the new law to obtain arrest. You know, Tallahassee has is sort of the main county in our circuit, but we have 5 small counties. And I talked to the sheriff in one of our counties, and just as a curiosity said, how many people do you have on in the jail at night? And he said, hopefully 2. And so that's a lot of research to ask maybe 1 or 2 people to do.
And if that level of research fell to the court system, if a judge felt they didn't have it, and it fell to the court system, do we even have the technology to be able to run those type of searches like that?
That is a question that I did pose, and I didn't get a real clear answer to it. Some of the information required for the jailer to decide whether the person would qualify is whether they've ever been on a conditional release from the Department of Corrections, medical release. I'm not aware of a database. No one could tell me that there was a database that contained that information. Whether this person had ever been declared a sexual offender or sexual predator in any state, maybe a standard NCIC, FCIC check would tell us that. Maybe it wouldn't. But again, here in Leon County, we have a very robust pretrial release department. They have people in the jail 24 hours a day, and when people come in, they're screening them. In some of our smaller counties where they've got 1 or 2 people working in the jail, are they going to be able to do this research to see if they've ever been declared a sexual predator in any state in the country, when they're also dragging people out of police cars to get them into the jail to be fingerprinted and mugshotted? It's an open question. And
those people, while waiting for paperwork that may or may not show anything, would then be denied bond and be sitting in jail until...
If they don't meet the criteria, then the statute requires that they see the judge for first appearance. Now, that occurs within 24 hours, as you know, but it is at least an issue for this court to consider.
Although, but just to be clear, I mean, these are hugely important issues you're talking about, but that has to do with the statute, not with our bonds, not with this. This is kind of the residue, right?
That's correct.
So these problems that you're talking about would flow from sort of the decision the legislature made to expand the category of charges for which there has to be a first appearance, right?
That's correct. That's specifically laid out in the statute, and of course the proposed bond schedule tries to track the statute. What we tried to do is come up with monetary amounts, and I know some of the comments that you're going to hear take some issue with the monetary amounts and the fact that there aren't conditions. The work group felt that broad categories were the best approach. And as you know from the chief judges that were appointed to the committee, we had judges from the Panhandle all the way down to Miami. That was never an issue. We never had anybody who said, look, we need to have a 160-page bond schedule, like one of the commenters attached to their comments. From the beginning, everybody said broad categories and leave specific requirements for drug testing, no weapons possession, and so forth, to the chief judges to sort of curtail, to make specific to their particular circuits.
On the amounts, there's a comment that highlights that St. Lucie has low failure to appear rates. I was wondering if there was any data available to the work group on failure to appear rates in the jurisdictions that had adopted bond schedules, and whether that informed the rates that were set, or whether it was just truly just trying to find the median.
We were trying to find what we thought were reasonable amounts that would fulfill our other statutes and rules for, protecting the community from risk of unreasonable harm and assure the defendant's appearance at trial. But we did not have any failure to appear data, Your Honor, so I do apologize for that. There is some comment about whether the jailer has the authority to hold the person prior to first appearance, irrespective of a bond schedule. When we looked at this, we found that there are basically 5 different ways that release on bond or not is handled in the state. There's at least one jurisdiction that gives complete discretion to the arresting officer on the arrest form. That officer checks hold for first appearance. If the person qualifies for the bond schedule, it doesn't matter. The officer says hold for first appearance, they're held for first appearance. In one jurisdiction, they give no discretion to the jailer, even if the jailer thinks the person should be held for first appearance. If they qualify for bond under the administrative order or under the bond schedule, they are allowed to post bond. In jurisdictions that have no bond schedule for felonies, everybody goes to first appearance. In some jurisdictions, the chief judge's administrative order adopting the bond schedule says the jailer has discretion to hold the person for first appearance. So it's not just the jailer making the decision. The jailer makes the decision backed up by the judge's administrative order. And then finally, in one jurisdiction, the bond schedule itself applies. However, law enforcement has the option to call the duty judge and say, Judge, this person qualifies for bond. They have the money. They have a bail agent. But here's why we think this person should be held to see a judge at first appearance. And then the duty judge, much like signing a warrant for a search warrant or arrest warrant, gives that officer the okay. So now we acknowledge that our rewording, the slight rewording that we're suggesting, does not provide a definitive answer as to whether, as the state attorneys argue, the jailer has unfettered discretion to hold somebody irrespective of a bond schedule, or whether it's a good idea for the chief judge of a particular circuit to give the jailer discretion. That's just what we suggested, to emphasize that the person does not have a right to pretrial release.
That seems like a pretty important issue to leave. I mean, there's some things that probably no one's thought of yet, but since that's something that you guys have been commenters have thought about, it seems like we ought to give more direction in here about that.
In all candor, when we had this discussion, there was not unanimous agreement about that. We had a lot of discussion, and I'm going to admit that I found myself, initially at least, in the minority. My position was, the legislature enacts a statute requiring a bond schedule. This court appoints a committee to study it. We recommend a bond schedule. This court sends out a statewide uniform bond schedule. And despite all of that, a jailer can say, I think this person should be held for first appearance. So they're going to be held. I think some direction from this court, or perhaps from across the street, might be helpful to that. There are some, as I mentioned, some of the bond schedules are massive, over 100 pages, dealing with very specific statutes. There was one comment about third-degree felonies that score as a level 7 in the punishment code. Of course, that means that they would score Department of Corrections time. I have a list of those. The ones that were specifically addressed were ones about sexual offenders and sexual predators. The statute and the proposed bond schedule already deal with that. Sexual offenders and sexual predators must see a judge for first appearance. So we didn't see that as an issue. We do appreciate the comments. They were very thoughtful, but we do continue to recommend broad categories, since this is a uniform statewide bond schedule, to be applied in our smallest of counties and in our large metropolitan counties.
Judge, I have a question for you.
Yes, ma'am.
I know you're recommending broad categories, but what about the argument raised by the prosecutors that we should perhaps consider also including some clarifying language about the DUIs and BUIs? Can you talk to us about that?
Yes. Of course, there are statutes and rules that require that you can't bond out if you're still under the influence, or at least until 8 hours after your arrest. If the question is whether there should be alcohol testing, scram units, and so forth, that's something that we thought the chief judges could address, since the law does allow the chief judge to raise the bond level and add conditions. For example, in one of my counties, we have alcohol testing, but for indigent defendants, it's a private contractor who does it, and costs cannot be waived. So, do we want to saddle these people with this cost or not. It does present interesting questions given that this is to be applied statewide. One final thought, I know I'm going to run out of time real quickly, is that we do unanimously recommend that you keep us in place for 1 year so we can study this and come back to you with any recommended changes. After that, we think it would probably be best to delegate this responsibility, since the law requires you publish it once a year, to perhaps the criminal courts steering committee. And I will be happy to address any questions or come back and speak
Thanks.
to you.
Yeah, and you can have 5 minutes back for rebuttal, and you'll be able to address, you will have heard some elaboration on the DUI stuff. And
Yes, sir. Thank you very much.
Get your response. Thanks.
Good morning, Your Honors, and may it please the Court. Derek Momsen on behalf of the Attorney General. So the Attorney General generally supports the Court's effort here to create a unified bond schedule on behalf of the entire state, with one minor exception to the broad categories the Court has proposed here, and that is for DUI offenses. And I think although these broad categories of offenses, I think it's generally a good way to go about this. I think DUI specifically is not amenable to the broad categories because of kind of its unique status, both in terms of its danger to the public and then also in terms of the liability risk to defendants who are charged. So first, one of the things this Court is charged with in promulgating this bond schedule is adopting a bond amount that is necessary to preserve the physical safety of the public. DUI is technically, well, first and second offense DUI is technically a second-degree misdemeanor, which would place it at the bottom of the bond schedule. But I think that DUI presents a much higher risk to public safety than your average second-degree misdemeanor. It presents an incredible risk of death, even a risk to human life, something that you generally don't see with a second-degree misdemeanor. So I think that it warrants adopting a higher.
Let me ask you this, and ask an interesting thought. The question of danger, is it that the person will bond out immediately after being arrested and still be intoxicated and drive again? Or is it that the person will recommit again at a later time? But what is the danger?
Yeah, so I think what we had in mind is the risk of recidivism. I think you do see high rates of recidivism in DUI specifically, and I think that when we talk about protecting the public, the Court often considers the crime that is charged and the danger that crime presents to the public, because there is a risk that person might reoffend on release. And then the other point that I would make is the legislature has treated DUI differently. Although technically a first and second offense are second-degree misdemeanors, the maximum sentence is significantly higher than other second-degree misdemeanors. So for a first offense, you have a max sentence of 6 months imprisonment. Second offense, it's 9 months. Typical second-degree misdemeanor maximum offenses or maximum sentence is 60 days.
Don't you have a second offense within 3 years, that you have a 10-day jail requirement?
Yes, there's also the mandatory minimum, which I think is also it just highlights why this is unique in the context of second-degree misdemeanors. Not only is it dangerous, but it also, I think the bond schedule the Court has proposed reflects the intuitive sense that as the potential sentence for a crime increases, so does the incentive to skip bail. And so a higher bond is then appropriate to counter that incentive, to ensure appearance at trial. So given the higher penalties that are for DUI and the fact that there can be a mandatory minimum on a second offense, that there are collateral consequences sometimes to driving consequences, that there is more at stake for a defendant than there typically is.
What would the AG's position be on amending this to say that second offenses and beyond, there's no bond without first appearance?
So I don't know that the statute would give the court the authority to adopt that, because the statute does set out certain crimes that are not bondable, and then it says the court should adopt a bond schedule for all other defendants under which they may be released.
I think you have to assume that whatever we do is going to be nominally voluntary, which leads to the next question of how is the statute possibly constitutional? I mean, I know you tried to pun on it in your brief, but it seems like it's either substantive and the legislature should just do all of this, or it's procedural and they can't tell us to do it. They could ask us or suggest that we do it or whatever. But it seems like this just can't be okay the way it is.
Sure. So I would actually take the opposite view. I think that it is okay regardless of whether it is procedural or substantive. So if the statute is procedural, then obviously the legislature cannot make this court do anything, but the court then has the independent authority to adopt the bond schedule.
So it's hortatory. It's a direction from the legislature that we ought to do something. Is that your position?
So that is not our position. If the statute is procedural, if that's what the court thought, that would be the case, and that is generally how the court has treated prior statutes that have touched on procedural matters. The court has treated that as basically the legislature's statement of the policy of the state. You know, this statute passed with overwhelming majorities in both houses.
Yeah, but we don't look into any of that. We don't count votes to decide what the law is. I guess what I'm trying to get at is how do you support this idea that it is the law, but yet it doesn't compel us to do something? I'm missing this.
Well, then, so I think you're correct. The statute would technically, insofar as it purports to compel the court to do something, if it were procedural, would not be constitutional. But
well, if it were substantive, would it be constitutional?
I think that it would be. It's at least
they could delegate their substantive lawmaking authority to us.
Yeah, so this court's case law does not have a categorical rule against delegation. The legislature simply has to articulate minimum standards that somehow the legislature has to set the policy of the state, and then the delegation has to articulate minimum standards that then the entity to which the authority is delegated can use to kind of effectuate the policy. And I think that...
So we could interpret the shall set as just a suggestion.
I'm sorry, can you repeat the question?
Yes, when it says the court shall set a uniform bond schedule and then gives the precise procedures that we should follow to do so, is it your position that that is a suggestion by the legislature to our branch, or is that a law that must be followed?
No, so I think we would say that the statute is substantive, or at least predominantly substantive, and that any procedural parts of the statute
And we're like an administrative agency, subject that's been given certain guidelines, and then we're an administrative agency to implement the substantive policy through this bond schedule.
Exactly, and there have been cases before. I know back there was a case where the legislature directed the court to adopt sentencing guidelines, and the court applied. It's the general delegation analysis that it applies to executive agencies to itself in deciding whether or not that was a constitutional delegation. I would reiterate, obviously, the position that we took in our comment that the court does not need to reach this issue in this posture. I think that the court could receive 40 pages of briefing just on the procedure versus substance distinction, and also on the delegation issue. The court does not have that here. The court has virtually no briefing. I think the public defenders...
But if that's right, then why is the right answer to permit something unconstitutional to happen as opposed to just asking for the briefing before taking a further step?
So this court's historic practice has been to, even when constitutional issues are raised in the public comment period, to reserve those questions, to adjudicate in an actual case or controversy to go ahead and promulgate the rule, allow stakeholders that are affected by the rule to then raise constitutional challenges, and then wait for this court to actually adjudicate the constitutionality of the statute in an actual case or controversy. We think that that forum is a lot more conducive than kind of this public comment aspect of a rulemaking.
So do we have the discretion to, I mean, it's telling us to do something that seems questionable in terms of the authority to tell us to do it, and it also seems odd to treat us like an administrative agency. I haven't read the sentencing case that you're talking about. I mean, do we have a duty to decide? I mean, we can address this by saying to the extent it's procedural, we do X, Y, and Z. But if we weren't going to do it that way, I mean, don't we have an obligation to determine for ourselves whether what we're doing is constitutional?
I don't know that I would say you have the obligation. I mean, I think that you could, but I think, I mean, this court has held that with respect to other entities, when there is a delegation, that entity doesn't have any authority to question the delegation. They simply should apply the statute. I would note the statute is presumptively constitutional.
But that's not an independent branch of government.
That's true, Your Honor, but I think in this context, in a rulemaking, it's not an adjudicatory proceeding, so we're not exercising the judicial power here.
But we've been told to make a rule by another branch of government.
And in that context, I think the court is acting then more like an agency in promulgating the rule rather than a court. And so the best practice would be for the court to wait for an adversarial proceeding to adjudicate the constitutionality of the statute. That said, regardless whether procedural or substantive, we think the court has the authority to promulgate the rule. If there are no further questions, I see that my time has expired.
Okay, thank you very much.
Good morning, May it please the Court. My name is Jack Campbell. I'm the State Attorney here in the Second Circuit. I'm here as the President of the Florida Prosecuting Attorneys Association. We're in support. I think Judge Allman and the group has done a good job. We've already addressed the two issues that have come up. With the modification that Judge Allman brought up, once again, we want to forward, just as the Chief brought, there are fact scenarios as a prosecutor that I can't even think of. I'm constantly baffled by what man can do in this state. I want to give a little bit of discretion to that booking officer, to that arresting officer, for the fact scenario of it may just be a trespassing, but it's scaring the stink out of me, and I would really like a judge to be making a decision whether this person is going to get out of the jail or not. That's kind of, we want a little bit of discretion to that arresting officer. Last night in discussing it, if I had somebody who jumped the governor's mansion wall covered in blood with, words to the effect that they were going to kill the people they find, it would be a trespassing, but it would be a scary one, and we probably need to do it. That's the type of thing. Honestly, probably, I'm with Judge Allman in the Second Circuit. Every day we have somebody at first appearance who is either suffering from some type of substance abuse or mental illness, where we don't even know whether they would understand the conditions of bond when they were talking to that booking officer. I want to get that booking officer the opportunity to say, I'd like you to talk to the judge. I'd like to have a judicial understanding that you understand that you're charged, that your court day is 30 days from today. Justice Labarga, you raised the DUI question. Obviously, the statute requires that we sober them up before we street them. Right. But the nature of alcoholism is the recidivism of it. So what scares us, of course, is that, sure, they may be, their blood alcohol may be well below 0.08 for the last 3 years. We may wait for it to come back down, but as soon as they get back out on the street, they're going to get a bottle and start drinking again. And as we know, and this court has seen on countless cases in life and in practice, DUI may be a nonviolent crime, but it's extraordinary violence. When those cars, it's just one bit. The difference between a DUI and a DUI manslaughter is one bad turn. And that's where we as the prosecutors recognize, whether it's a BUI or a DUI, we'd like to go ahead and get a little bit. I understand Judge Allman's discretion, and I'm deferential to it, but in as much as we're doing something statewide, DUI, BUI is probably, other than domestic violence, our second most popular crime that we're dealing with repeatedly. So a standardization recognizing that, once again, the court could go ahead and address, particularly as the chief raised, on second and subsequent DUIs, we already have evidence of a recidivism issue. You also have lots of these diversion programs that are coming in at this point. So what is a truly second DUI or BUI? If I've completed the Broward County diversion program 6 weeks before you caught me with a new DUI, is that a first offense? Am I truly going to be released with no conditions concerning, once again, my alcohol?
So I'm clear, under the proposal, a first DWI, let's say I got arrested for the DWI, I would have to wait to see the first appearance judge before I'm released.
That would be the recommendation of the state attorney. Once again, it starts to get, because there is the special requirement that they sober up beforehand, often those come in late at night, often first appearances in the morning, so those kind of start running into each other where they are. The other thing I would mention to the court is what I think is going to be a renaissance, not in a good way, concerning DUI law is marijuana in our state. If that, as medical marijuana, and if should this court and others, legalization of marijuana continue to go, that is going to change DUI astronomically. And once again, .08 and a lot of the progeny that we've done concerning when somebody is still, quote, high, that's all going to change. And this course doesn't deal with well, I can put them on the intoxilizer and find that their blood alcohol is below .08. I won't be able to do that with a THC level. Once again, I think it's important that the court, and that's what, just like the committee says, it goes back to the foundation of a judge looking at a defendant, a charged person, and making a decision. Do you know where you are? Are you safe to go into the community? Are you able to maintain the integrity of the system by showing up and following the conditions I give you? That should be the fallback position I'm all about the efficiency of getting these guys out. We certainly don't want to, I'm not looking for more work, and it's my people who are going to be at first appearance, but I don't want someone to get out because of an automatic system where we shoulda, coulda, woulda. Everybody, the arresting officer, the booking sergeant, thought that we should get this in front of a judge, but we didn't because we let procedure run good common sense. And with that, I don't even see where my lights are, but if there are any other questions, I'm happy to answer them. All right. Thank you all very much.
Thanks.
Good morning. Please the court. Wayne Evans. I'm General Counsel for Florida Sheriff's Association. We appreciate the opportunity to speak to the court with respect to the bond schedule, which we think is beneficial for all the parties, and we applaud the work of the work group in the proposal. I want to begin by saying we have particular concerns with a couple of offenses. We do no longer have a concern with the sexual predator issue. After filing the comments, it was readily apparent that that was adequately addressed. But we have two other offenses that we think are significant, one with respect to public safety and another one with respect to the safety and security of a jail. And the first one that I would like to bring to the attention of the court is fleeing and eluding, which is a violation of Section 316.1935. That's a third-degree felony, but similar to what Mr. Campbell was saying with regard to DUI, it's a bad turn away from becoming a first-degree felony with regard to somebody being killed or seriously injured. As things stand right now, as I understand the bond schedule, fleeing and eluding with the third-degree felony because there's no use of force or threat of force, that's $2,500 for the proposed bond. For us, that seems to be grossly insufficient with regard to the risk that's presented to the public, with regard to the conduct that's there, the inherently unsafe conditions that are created when somebody either flees from an officer when the lights and siren are activated or during a stop and then the driver takes off.
I read about this fleeing and eluding constantly on the turnpike or I-95 or the interstates, and people going 150 miles an hour running away from police. And it seems to be pretty spread out throughout the entire state. Why hasn't the legislature acted and not made that into a second-degree felony or something higher?
Your Honor, I can't speak for the legislature, but I can speak for the Florida sheriffs with respect to the bond.
Well,
And-
I'm
Yeah.
asking you as the lawyer for the sheriff's office, has the sheriff
Well, perhaps,
requested?
perhaps that's an issue that may be addressed at another session, but my focus today is to address the proposed bond. And with respect to the bond, $2,500 seems, again, grossly insufficient with respect to the nature and the level of the conduct that's involved. So we would ask that y'all take a closer look at that particular offense. The second one that I would like to talk about is introduction of contraband into a jail. The statute, and that's 951.22, differentiates between felony contraband and misdemeanor contraband. The felony part of it would be if a firearm, controlled substances, or a cell phone are introduced into a jail. The misdemeanor part of it would be any other contraband. Typically, that's going to be alcohol or tobacco. The particular offense of introducing a firearm, that's a level 6 offense. With respect to alcohol and tobacco, that's a misdemeanor offense. That's $500. That's it. With the phone and the controlled substances, that's a level 4 third-degree felony. And if we're talking about what the bond would be with respect to the felony and with respect to the misdemeanor, the felony, again, because there's no use of force or threat of force, $2,500. And the obvious issues, the security issues that are presented to the jail with introduction of a firearm in particular, or the other issues that are created when you have contraband and a cell phone that are brought in, certainly seem to deserve much more than a $2,500 bond. We would also ask y'all to take a look at the misdemeanor, which again is just $500, but if you're introducing into the jail alcohol and tobacco, obviously that creates security issues for the jail as well, and problems that would need to be addressed, and we feel that the $500 again is grossly inadequate for the nature of the particular offense that's being committed. Again, we speak in support of the comments of the state attorney with regard to the DUI and think that that deserves closer attention as well. And I'd be happy to take any questions if y'all have them at this time. Thank y'all so much for your time. I appreciate it.
Thank you.
May it please the court. My name is Kerry Carlisle. Florida Bail Agent Association President Michael Harrison was supposed to appear today. He has contracted COVID. He sends his apologies. I am here in his place. I've been a bail agent for 35 years. I've dedicated my career to learning, teaching, and mentoring other people about the bail profession. I am the Vice President and the Legislative Affairs Chairman of the Florida Bail Agent Association, and I am their representative here today. Through the FBA, I've helped craft many statutes in Chapter 648 and 903. Our association was established in 1972 as a trade organization representing the bail surety companies and the bail agents of Florida. We are committed to holding criminal defendants accountable by ensuring their appearance at all court appearances, which we believe and we know protects our communities for safer communities. As we explained in our comments provided with our submitted recommendations, given the broad experience of our members with different bond schedules across the state and the nation, we are uniquely qualified and positioned to assist the court on the industry's best practices of what works and what does not work. We appreciate the opportunity to be here today. Your Honors, we appreciate the proposal of the work group and their efforts. While we agree with the work group in many areas, we have two major areas where the proposed schedule could be improved. First, we believe that an offense-specific schedule similar to the Miami-Dade bond schedule would best serve the citizens of Florida. An offense-specific schedule relieves the arresting officer or the booking officer for making a determination of what level of crime the defendant has committed. The schedule proposed by the work group forces an arresting officer or booking officer to decide that what level of crime is appropriate, a skill he or she may not and most likely has not been trained to do and may not have the experience to do. An offense-specific schedule also guarantees the defendants across the state are treated equally regarding the setting of bail. There is no ambiguity. An offense-specific schedule also differentiates crimes. Not all crimes within a particular offense are the same. For example, tampering with an odometer is a third-degree felony. And solicitation of a child via a computer to commit a sex act is also a third-degree felony. Under the proposed work group, both offenses would be released under a $2,500 bond. We submit that most citizens would feel the $2,500 bond is appropriate for the odometer. However, the same amount of bond for someone accused of luring a child to hotel, motel to commit a sex act would be far too low. We do not suspect that most citizens would feel the same amount. The bond amount should be the same for both offenses. The second item, if this court should agree with the work group's grouping of offenses, we believe the amounts in the proposed schedule are far too liberal and do not strike the proper balance between the different requirements out by the legislature, which appears to be much more conservative than the proposed bond schedule. Florida Statute 903-046 states the purpose of a bail determination is to ensure the appearance of the defendant at all court proceedings and to protect the community against unreasonable danger from the criminal defendant. In many instances in the work group's proposal, the bond amount is lower than the fines and fees the court will impose on the defendant. Also, the bond amounts for many crimes such as DUI and petty theft are lower than the defendant's bar tab or lower than the item the defendant is accused of stealing. The recommendation of the work group for these low amounts, in our experience, is not compatible with 903-046 in ensuring the return of the defendant to all court proceedings and protection of the community from unreasonable danger from the criminal defendant. The recommendation of these low bond amounts does the complete opposite. The issuance of these low bonds has no consequence for the defendant to appear in court. The bond amount should reflect the seriousness of the crime. While it's not in our purview to advocate for specific bond amounts, from our experience, the proposed bond schedule does not achieve the balance necessary of defendant's appearance in court and to protect our communities. I would like to remind the court the bond amount schedule, the part of the schedule dealing with bond amount, only applies from the time of arrest to the first appearance. The first appearance judge is not bound by those recommendations. We'd like to go on the record and state that we fully support the comments of Florida Sheriff's Association, Florida Prosecuting Attorneys, and the Attorney General, and to thank Judge Allman for his work with the work group and being so gracious to listen to our input. In closing, we ask this court to consider an offense-specific schedule, similar to the Miami-Dade bond schedule. Although an offense-specific schedule may be considered unwieldy, it best serves the people of Florida by guaranteeing the defendants are treated equally across the state with no ambiguity in the setting of bonds. Alternatively, if the court should favor the work group's proposal of a grouping bond schedule, we would recommend that it more closely resemble the St. Lucie bond schedule, which would be more effective. We appreciate the opportunity to appear today for this honorable court and discuss the proposed schedules, and I welcome any questions. Thank you.
Thank you very much.
Thank you.
Just briefly, Chief Justice Curiel and other justices, to pick up on Justice Labarga's comment, DUI and BUI, fleeing and eluding, may be different, may be very serious. The legislature, in enacting this statute, exempted a lot of, I should say designated a lot of misdemeanor crimes that require first appearance. Domestic violence, stalking, failure to appear, violation of injunctions. They did not address DUI and BUI. The work group is not suggesting that some pretrial release conditions on DUI and BUI are not warranted, but just suggests that those should be left to the chief judges in the individual circuits to tailor them. And as far as, you know what, I'm going to stop there.
How much variation and complexity do you anticipate arising from the chief judges? This is obviously a floor It sounds like, I mean, one thing that the chief judges, assuming that we put this in the order, the chief judges could just raise these dollar amounts. But as far as these other types of things, are you assuming that a lot of that is going to be happening, or you know, how extensive is that going to be, do you think?
That is an interesting question, and it does raise the question of how uniform is the uniform bond schedule going to be once 20 different chief judges have to tailor these things to fit their particular circuit. I can certainly see the rationale with some conditions for DUI and BUI and maybe fleeing and eluding. I don't think I can answer how widespread those variations will be. There may be some lobbying from the prosecutors and the public defenders, maybe the defense bar to the chief judges to ask, maybe even the bail agents to ask that, you know, different bonds be put in place. I don't know. I would think overall they would probably sort of come to rest at some kind of an equilibrium, but exactly identical, I would not expect that.
Is there, to the extent that there are lots of circuits that already have bond schedules, is there sort of a norm as far as process or opportunity for comment or public input before they're adopted? And I'm specifically wondering, to the extent that chief judges are going to be adding to this, is there anything that, you know, not trying to reinvent the wheel or be overly prescriptive, but is there anything that would make sense to put in here to say that if chief judges are going to exercise their discretion to add to this, that they should do, you know, X, Y, or Z before anything goes into effect?
It's a good point. I think the chief judges across the state would agree that it's always a good idea to get some input from stakeholders. I'm not aware that we did that in the Second Circuit when I was not chief, when this current administrative order imposing, or I should say setting out the bond schedule was put in place. But I know I, as the chief judge now, would appreciate comments from the Public Defenders Association or Factil or the prosecutors. You know, whether we adopt any of them would be left up to each one of the chief judges.
The one thing that impresses me is Florida is such a huge state. And the problems in Miami-Dade are much different than the problems in Pensacola or St. Lucie County or Orlando or Tampa. Each region has its own issues, and they have to deal with a particular county commission they may have that's funding the sheriff's office and the jail and all kind of politics center. And so to have this statewide type, broad brush type of bonds may not serve certain particular communities, you know, wisely. In which why I think the chief judge in each circuit court in each area should have a greater say or a big say in what this bond schedule should be, and they can adapt those depending. Like for example, in 1980, when I was a young prosecutor, we had this huge boat lift from Cuba that hit Miami like no place else. Now the bond schedule was meaningless at that time, and a statewide bond schedule would have been meaningless. Other issues happen around the state. So I think chief judges should have some discretion, a lot of discretion in deciding these things. That's just my view.
Yes, sir. Well, and obviously the legislature anticipated that, and you know, I love our northeastern states as well, but Florida is not Rhode Island.
Right.
It's you know, we've got a lot of different counties. My circuit, we have some very small counties, and then one sort of metropolitan county, but we are worlds different than Orlando or Miami or Tampa. And it does make sense for the chief judges to be able to tailor these to the specific needs of those circuits and maybe even those counties. Thank you very much for your time, and I appreciate again, and so does the work group, the opportunity to serve.
Yeah, thanks again for all your work, and
Yes,
thank
sir.
you everyone who commented and who came today. We appreciate it. We're adjourned.
All rise.